Good afternoon. Well, we have a big turnout today. Glad to see all of you here. Welcome to the Appellate Division, First Department. Today we have some 6 hours of argument time requested, so please keep that in mind as I call the cases. Remember that we have your briefs, we have your record, we're fully familiar with the facts of the case. And first case is People versus Demetrius Washington.
On behalf of Demetrius Washington, I'll request 7 and 1, Your Honor.
7, 1, and 6, thank you. Ovalis Sosa versus Lotless.
On behalf of the appellant, a lot less, I'll ask for 6 and 1, Your Honor. So on behalf of the plaintiff, respondent, 2 minutes, please.
Give you 5 and 1 and 2. Thank you. Harry T. versus Lana K. Both cases 2519 and 3945. You are the respondent on both?
On one of the appeals, we are the respondent, the other one,
The appellant. And is there anyone here for Harry T.? So do you wish to submit? No. Okay, well, I'll give you 2 minutes. Park Merst Investors versus WeWork Companies.
respondent, Your Honor, 6 minutes.
6, 2, and 6. DeJesus versus Downtown Holdings. Just a moment, please. Okay. Okay, for Downtown and Noble? So you're the appellant on against a number of parties, are you not?
I am, Your Honor, my primary position is as a respondent to the appellant and the appellant respondent.
Okay, so the appellant, Rockledge?
Yes, Rockledge, appellant respondent, Rockledge respectfully request.
If you could speak up, please, sorry.
No problem. Appellant respondent for Rockledge, 6 and 2.
Okay, is there another appellant?
Here is. Counsel for third-party defendant, respondent, appellant, next generation. And I ask for 2 minutes and 2 in rebuttal. 5 minutes and 2 in rebuttal, sorry.
I'll give you 4 minutes and 2. Any other appellants?
Yes, Your Honor. Michael Kelly,
For
third-party plaintiff, second third-party plaintiff, respondent, appellant, Stratford Steel, 3 minutes.
And no rebuttal?
No rebuttal.
Okay. Now for our respondents. Is there one?
I represent
TS.
fourth third-party defendant, appellant, respondent, the safety group.
TSG, yes.
I request 6.
You asked for, I didn't hear how much you asked for. 6 and 2. I'll give you 4 and 2. Just let me make sure. Rockledge, I'm changing to 5 and 2. Okay. And now we have our respondents.
Your Honor, for respondent, City Safety Compliance Corp., I request 4 minutes.
Okay? Okay, is Next Generation up after that? Who's up after that?
I'm counsel for Next Generation. I'm not sure what order we'd be arguing in, but I am an appellate respondent. So
Yes.
most of the time.
Okay. Yes. Okay. There you. Just you.
Respondents, appellants,
Da-
downtown, available. I've been requesting 5 and 2.
5, 2. Okay, I think I have everyone. We start with Rockledge, 5 and 2. Next Generation, 4 and 2. Stratford, 3. TSG, 4 and 2. City Safety, 6, I think, did I give? No. You asked for 4. Yeah, I'm sorry, 4. I'm sorry. And Downton, 5 and 2. Okay, downtown, 5 and 2. All right, just give me a minute to record all of that. Okay, thank you for your patience. People versus Dominique Francis. 4, 1, and 4, thank you. Barnett versus Berkowitz.
Hi, for appellant, we request 9 and 3 for rebuttal.
6, 2, and 6, thank you. People versus Harris Curtis is submitted. Sokola versus Weinstein.
Good afternoon, Your Honor. We have 3 groups of appellants. We would request 12 and 3 total, and so we would divide that equally, so it would be 4 and 1 each between the Disney appellant, Miramax, and the Weinstein.
And
For respondent, Pius Cola, we request 8 minutes total.
I'll give you 9 and 3 and 8 and 1. You have 3, that's 3 minutes each, and I gave you 9 and 3, yes, and 8 and 2. 8 and 1, yes. 8 and 1? Oh, I'm sorry, 8, yes, 9 and 3 and 8, sorry. Weiss versus Ream.
Good afternoon, Your Honor. Ellen Werther for Plaintiff Appellate, and we respectfully request 6 and 2.
Good afternoon. For respondents, 5, please.
5, 1, and 5. NW Media versus IBT Media.
For appellant NW Media, I request 8 and 2.
For respondent, we would request 8.
5, 2, and 5. People versus Luis Medina.
For appellant Luis Medina, requesting
6, 2, and 6. Wu versus Uber Technologies.
Appellant requests 8 and 4. Respondent requests 7 minutes. Respondent requests 7 minutes.
And you, sir? Are you going to make that application now, or are you just going to? Well, since you're standing, I figured you. Okay, all right. 7 and 2 and 7. SKW Hillside versus Rabizadeh. I'm sorry, I've definitely gotten that wrong.
Appellate Homes and More, it's Albert Rabizada, I got it wrong too. And I'll take 5 and 2, please.
Sir, for the respondent?
And for plaintiff respondent, we'll take 4, please, Your Honor.
I'll do 5 and 1 and 4, and People versus the State of New York versus Tyson Foods is submitted. We're taking the cases out of order. The first case is going to be called as De Jesus versus Downton Holdings.
Sign them.
Just a minute. Okay, you may begin.
Thank you. Good afternoon, Your Honors. My name is Jerry DeCamp from O'Connor Red Orlando. I represent the appellant respondent Rockledge Scaffolding Corp. My first request is that the lower court basically overlooked the salient facts and when it dismissed any claims with respect to...
I'm sorry, I'll stop the clock, but you need to move over a little bit so that we can get you in front of the mic.
Oh, okay, sorry about that. We're crowded up. Sure.
Okay.
Okay. So basically, we're seeking a reversal of that part of the lower court's decision, which overlooked the salient facts in dismissing Rockledge's claims for common law indemnification against the defendant respondent Noble Construction Group, who was the GC on this project, and finding that they were not negligent in contributing to the plaintiff's accident. The court did not make note of any of the admissible evidence that Rockledge put forth in their papers below, which included the sworn testimony of Mr. Rafael Medina, who was the foreman for Rockledge and who was on site and was part of the construction of the sidewalk bridge. Mr. Medina.
So your argument is that Noble bears responsibility because Healy was the coordinator of the trades and was aware of the 3-foot gap between the building and put plywood there instead of conforming, so there are questions of fact.
Absolutely. There
with
is,
regard
yes, there are
to-
definitely issues of fact, not only aware, but that also Mr. Healy then instructed Mr. Medina to put those planks and those boards there, and then also advised that Noble themselves was going to be putting plywood as well
Your
over that.
position is they shouldn't have gotten summary judgment on the common law, I think.
Correct. And that
common law
there shouldn't
indemnity.
have been a finding below that there was no evidence of negligence on behalf of Noble. Clearly, there's
Well,
several issues
question of fact means that that wouldn't be the
Yes,
case.
correct.
That's what your argument is, right?
Correct, Judge.
And your next argument?
My next argument is that with respect to the contractual indemnification claim by both Noble and Downtown against Rockledge, that the lower court's grant of that is premature. One, because of all the evidence that was submitted with respect to Noble's negligence, and they cannot be indemnified for their own negligence as it violates the GOL. And the other, with respect to Downtown and Noble, is that there's issues of fact as to whether or not Rockledge's erection of this scaffold is enough to trigger the indemnification provision in the contract, which requires that the claim or accident arises out of or is in connection with Rockledge's work on this project. I mean, there's definitely an issue of fact with respect to that. A jury, based upon the evidence and with respect to Noble's control over not only the erection of the sidewalk bridge, but also with respect to the rigging and hoisting operations, as testified to by their own former New Generations, and their failure as the general contractor of this
There's a
project.
question.
Oh, I'm sorry.
The sidewalk bridge was installed by Rockledge,
Correct.
and there was a gap left in the installation of the sidewalk bridge.
There was a gap at the edge of the
between the
sidewalk bridge to
building?
the slab of the building, correct?
Right, and I guess it was a supervisor or Medina,
Correct,
who was an
Raphael.
employee of Rockledge,
Correct.
knew about the gap
He did.
and felt that that should have been corrected.
Well, he went to the general contractor, superintendent in charge of the project, Mr. Jason Healy, and told him, and asked him, what do you want us to do with this? Because we constructed it per the plans, but there should have been a face or facade on the building, and that was not yet there. So that was the gap was there.
But the
That's why
gap was not properly covered by Rockledge Medina, so that raises a question of whether or not Rockledge was negligent. And then the question is, did the injuries that were caused to this plaintiff somehow did they arise in part out of the sidewalk bridge not being constructed or erected in a proper manner?
Well, respectfully, Judge, it was constructed and erected in the proper manner because it's required that it be built up to or within an inch of the facade of the building. The problem was the facade was not yet on the building, and that's
Then
not
how
under
could
the
it be
purview of
proper if the
Rockledge.
facade wasn't on the building? It
Correct.
wasn't, if the facade wasn't on the building, then it wasn't up within 1 inch of the building. The structure that was there while people were working existed, and the scaffolding was 3 feet away from it. I understand that they expected to put the building, the facade in there, but it certainly didn't happen before the accident happened. It could have been reconstructed at another time, but that's not what happened.
And to that point, Your Honor, this was erected in August of 2016, and Rockledge did not know that the face of the facade was not going to be put on the next day, the day after. That's under the purview of Noble. They were there, Rockledge, for 2 to 3 days to put up this bridge and left. Noble never called and said, we need you to come back because we're not putting the face of the building on until X time. And also, too, the violation for this was actually issued to Noble. Noble paid the violation, and Noble, under the contract, had the right that if they thought Rockledge was responsible, could have sought repayment for the fine that it paid, and it never did, which I think speaks volumes as to whether or not Noble realizes that this was actually under their purview and not Rockledge's, because they never saw the compensation for the fine that was issued to Noble if they actually indeed thought it was Rockledge's responsibility.
Okay, thank you.
Thank you, Your Honors.
Next generation, I believe?
Yes, Your Honor.
Okay.
Good afternoon, Your Honors. May it please the Court, my name is Lisa Fleischman, and I represent Next Generation. Your Honors, I'm here on the simple issue to demonstrate that Rockledge was, at the very least, 1% negligent here, and that there are no disputed facts as to that point. We ask reversal for 2 reasons. The first is that the lower court found, with respect to the claims between downtown and Rockledge, that there was the accident, it was uncontroverted that, at least in part, the accident was caused by Rockledge's erection of the subject sidewalk bridge. That finding should as well preclude any claim of common law indemnification as to Next Generation. The operative word being uncontroverted, the court found that. Now, with respect to Next Generation, the lower court found that there still has not been a determination, if at all, as to Rockledge's negligence. But I submit that that was incorrect. the lower court found that it was uncontroverted, that there was some negligence on the part of Rockledge. And uncontroverted means no question of fact. And that being the case, the lower court's findings should preclude a finding of common law indemnification as to next generation. Moreover, we ask reversal for several other reasons. First of all, Rockledge did not construct this bridge in conformance with the code and in conformance with the plans. Rockledge operatives, Medina and McEntee, said, oh, yes, we did, but the proof does not bear that out. Joel Fagu, the engineer, testified at deposition it was not constructed according to plans because the decking of the shed did not reach to the structure of the second floor, the slab, and so it was not safe. It was not constructed according to code. Our engineer, Robert Flynn, whose testimony was put in admissible form on reply, let there be no question regarding that, testified that it was not constructed in accordance with plan and in accordance with code. Moreover, the photos show that it was not constructed flush against the structure. There was a 3-foot gap. The Department of Buildings violation was issued because the bridge was not constructed according to code.
So Next Generation's responsibility was to hoist this steel pillar, or whatever what you'd call it, and a link broke.
Yes.
Is that correct?
Correct, Your Honor. And I'm not here to talk about my client's potential role in this, if any. Our concern is solely with Rockledge, and if Your Honors find that there is the slightest bit of negligence there, then the common law claim has to go out. Your Honors, there is more. Rockledge was obligated to, once it realized that there was a gap, there was no face of the building, was required to go back to its engineer to get new plans so that the engineer could draw up new plans, get approval from the city so that that setback, that 3-foot setback, was taken care of. There
So
would
your
be,
point is if either party is negligent, neither one is entitled to common law indemnification here. And there's negligence on the part of Rockledge here.
there's absolutely negligence on the part of Rockledge, Your Honor. Rockledge was negligent because it filled the gap with non-code.
I think we have your point,
All right. thank
unless
you,
there's
Your Honor.
something else.
What was that?
I said, I think we have your point unless there's something else.
I just want to point out that the filler that was put in were planks, wooden planks, and that was not according to code. That was not sturdy enough for the code. That's another reason for negligence. And finally, Rafael Medina, the foreman, certified that the bridge was in accordance with code. It was not.
Which all goes to the same point, that Rockledge is negligent because they didn't put up the scaffolding properly.
Precisely,
Thank
Your
you.
Honor. Thank you.
Stratford, I believe?
Good afternoon, Your Honors. My name's Michael Kelly with the law firm of Marshall Dennehy for Stratford Steel. It is our position that the lower court erred in granting summary judgment and dismissal with respect to the causes of action asserted against city safety for common law indemnification and contractual indemnification. In short, it's our position that city safety did not make a prima facie showing of entitlement to summary judgment with respect to those two causes of action because its motion papers did not address the fact that it had been retained and in its contract was there to observe and report any violations of Chapter 33 of the building code, and it is almost uncontroverted that this hole in the sidewalk shed was a violation of Chapter 33 of the building code. Furthermore, CSC, or City Safety's representative, was at the building site.
What were they in charge of doing, city safety, if they saw that there was a violation?
By my reading of the contract, they were to report it, I believe, to Jason Healy. So that would be the short answer to your question, Your Honor.
Basically report, but they had no authority to stop the work or do anything else other than report.
Well, I would disagree with that to the extent that John Nicolia of City Safety testified that if he saw an imminent danger at the site, and I'm paraphrasing, he would have stopped it. I submit.
Wasn't their main role to be advisors? Weren't they in an advisory capacity? And that was in the contract, written specifically?
Well,
They had no authority to supervise the contractors or to control or to stop the work?
I would agree that that's what the contract says, Your Honor, but I would also submit when Mr. Nicolia is at the building for months and months before the accident, doing 5 to 7 walkthroughs a day, specifically retained under the contract to identify and report Chapter 33 violations, and doesn't report to anyone this hole in the sidewalk shed, that he has violated the terms and the spirit of the contract. I would also submit, Your Honor, that CSC deviated from industry standards when it did not investigate the hoisting equipment that was at the site for months and months. I believe the testimony was that the hoisting equipment was there since February, but Mr. Nicolia, despite doing 5 to 7 walkthroughs a day, never took any steps to identify it. I would also further submit that Stratford Steel raised a triable issue of fact about, in essence, deviations from industry standard by CSC when it's an expert affidavit to its opposition papers to CSC's motion, which sufficiently outlined the deviations from industry standards. Edmund Warren, who testified in this case, echoed our experts' opinions about the deviations from industry standards at the site.
Thank you.
Thank you, Your Honor.
City safety? Somebody knows who city safety. One of you should know who city safety is. Okay. Okay.
William O'Connell, Goldberg Segala for Respondent City Safety. I'm just going to backtrack right to what counsel last said about Mr. Warren and his testimony about the hoist and how it should have been noticed. There is testimony also from Mr. Warren on page 4695 of the record, which says, and if that tarp had been over the winch when you were doing your walkthrough, would you have taken it upon yourself to lift up the tarp and look underneath to see what was there? Answer, I don't know. So their expert himself, or self-proclaimed expert, he was actually an employee of that company, it says he might not even have lifted up the tarp, which was there for a while. It's our...
Counsel, if I may.
Yes.
What, if any, evidence was in the record that your client either directed, supervised, or controlled the work?
It's a complete false statement. There is no evidence of supervision and control, and by contract, that was brought up a little bit before, they were actually prohibited. It said they have no authority to supervise or control. So even if Mr. Nicolia, when he testified, said, yeah, if I saw something imminent, I might stop it. Well, to me, that's just an answer as to what a human being would do presented with a situation. He had no authority to do that. So I think that's really what governs here.
Understood. And it was Noble who had the authority to stop the work.
Well, Noble is the general contractor here. They did have absolute authority for everything. In fact, the language, unlike my client, refers to sole responsibility with respect to safety programs and precautions. So in terms of trying to rely on breaches of contract to establish that my client was negligent, the site safety manager, they were the ones who were, quote, solely responsible for safety. We were just advisory, and we were supposed to essentially tattle on somebody if we found them. But just to quickly get to the contractual indemnification claim, Stratford argues that, but they don't even have a contract with us, so they should just be disregarded. Noble does have a contract with us, but they forget to say the contract had reciprocal indemnity provisions, where essentially whoever commits the act or omission that causes the accident is the one who's responsible. The court obviously believed our evidence that we did what we were told. My client said he did not see under the tarp, and he did not see that gap. He did do walkthroughs, but it was covered with wooden planking and longer planks. So he obviously said he didn't see it. There's no evidence in the record to the contrary other than speculation that he may have seen it because he was there. And we believe we've met our burden to show we were not negligent. They also were negligent, so they can't get common law indemnification anyway. And for the same reason, contractual indemnification, we did not commit an act or omission that led to this loss. So if there are any further questions?
Thank you.
Okay, thank you, Your Honor.
Sorry. I'm sorry, you were just city safety, right? Okay, all right. We are downtown and Noble. Oh, I'm sorry, TSG.
Apologize, Your Honor, there's too many, everybody likes using the word safety in their corporate name.
I see that. Must have something to do with construction, probably.
May it please the court, good afternoon, Your Honors. My client, the safety group, is essentially the employer of the plaintiff in this case. So obviously there's no common law counts against the employer. And I'm just going to move on to that. The only issue here is the contract in which Noble sought a summary judgment motion that required us, TSG, the safety group, to indemnify them for the accident that occurred to TSG's own employee. And the lower court clearly...
You didn't present any information on, you didn't present any contract or any...
Actually, there is a contract in the record, Your Honor.
With regard to you're talking about the indemnity or the procurement of insurance?
No, what we're talking about here, Your Honor, is whether or not the safety group has to indemnify Noble.
Contractual indemnification.
Correct. That's clearly in the record. I hope there's no dispute as to that.
Yes.
Because the lower court, in granting Noble's summary judgment motion and denying our summary judgment motion to seek dismissal, said it was uncontroverted at the time of the accident. Plaintiff was employed by and performing TSG's work. That is correct. Therefore, because there was a connection between the accident and TSG's work, Noble is entitled to indemnification according to the terms of the
Your argument is you had no role in this. You simply had the plaintiff, who was the one on the ground, not hoisting, not moving, not building a scaffold.
I'm not arguing that, Your Honor. The contract says that.
The contract says that.
The facts say that. In fact, Noble's own witness in testimony said specifically when asked whether or not there was any relationship between TSG and the work. Here, question, in regards to the accident, which is the subject of the lawsuit, was the accident in any way a consequence of the performance or non-performance of the work performed by the safety group? Answer, no. Question, was the accident in any way related to the performance or non-performance of the safety group's work? Answer, no. And I thought I just answered that right before that. Their own witness says, hey, the safety group had nothing to do with hoisting a steel beam 11 stories up in the air, which crashed through the sidewalk shed and hit our employee on the ground floor who happened to be standing in the wrong place, wrong time. That does not meet the satisfaction of a consequence arising out of, in connection to. And that's not new law. That's something which, in exactly almost identical facts, this case, this...
I think we have your argument. I think we have your argument on this issue. Did you want to go to the other issue?
Of insurance procurement?
Yes, I don't know if you wanted to...
Well, essentially, if we're not responsible, then the insurance procurement clause becomes moot.
Except you didn't provide... Was your motion for summary judgment?
Well, we did provide insurance. There's no doubt. There's no question of that.
Is there a contract in the record?
Yes, it's in the
on the insurance procurement issue?
As far as the contract lays out, the requirement of insurance procurement, that's in the contract, which is in the record. And I don't believe there's any dispute as to the fact that insurance was procured on behalf of the safety group and in accordance with the certificate of insurance. But there's no trigger because we had nothing to do with the accident. And that's something that this court has repeatedly held in the court of, and I cited the case law, the Burlington insurance case and whatnot. So all I'm asking this court.
I think we know what you're asking.
Okay, well, there's two things. One, Noble should not have gotten summary judgment against us requiring indemnification. And two, we think we should have one summary judgment getting out of the case. At the very least,
Thank you.
Noble should not have gotten summary judgment. Thank you.
Thank you. And now, downtown. And Noble. Heard a lot about you. Let's hear what you have to say.
Good afternoon, Your Honors. May it please the court. My name is John Pashesky, represent downtown and Noble. I think you've heard all of the issues that are at play here today, so I'll kind of, I think, cut right to the chase. Obviously, we believe the court correctly decided the motion with respect to granting contractual indemnity against TSG and Rockledge and dismissing the cross-claims and counterclaims of all parties against my clients.
What did TSG do?
TSG was, as counsel said, the employer of Mr. De Jesus.
Okay, so he's the injured party.
Excuse me?
He is the injured party. Were
Correct.
they lifting anything? What would they do? Did they put up the?
They were not, Your Honor.
sidewalk
They
bridge?
contracted specifically to provide labor services, Mr. De Jesus' services, to the project. Their contract specifically includes work that is providing labor. The
But
contract,
that labor that he was providing, was that labor in any way related to the accident?
it was related to the accident because he was hit by a steel beam. He is the accident. There is no accident without Mr. De Jesus being injured. That's the
So
whole-
TSG has to pay because their worker gets injured at the work site.
According to the contract terms, absolutely, Your Honor. Specifically, their contract, and this is something that TSG does not address at all in either its appellant's brief or its reply papers. They assume the sole and exclusive responsibility for the health and safety of all of their employees, that's Mr. De Jesus, at the project site. And that's right in the miscellaneous provisions of the contract in the record on page 1813. They specifically assumed a responsibility for his safety. That's one of the things that they contracted for, and their contract merely calls for indemnification in connection with the work in the contract.
It doesn't say with the performance of the work?
The specific language, Your Honor, is in connection with or as a consequence of the performance or non-performance of the work on the project by TSG. The work is providing labor services. The connection is Mr. De Jesus being at the project pursuant to the contract with TSG and being injured. And under Regal, the Court of Appeals has held that there is a connection between employment and the injury. That's the connection that triggers the indemnification. And this court itself has held that as well in, pardon me while I find that, recently in Fugger versus Amsterdam House for continuing care retirement community. There, one defendant was was entitled to conditional indemnification from another, the employer of the plaintiff, by this action in which plaintiff, a Carwin employee, seeks damages for injuries he sustained while performing Carwin's work. Simply, the employment, performing the work, was the trigger for the indemnification.
Also, but this says as a consequence of the performance or non-performance of the work. So you're saying just by being there, that's as a consequence?
Just by the fact that he is an employee that has a connection to TSG's work, which is providing labor services. That is the work.
That provision of labor services has nothing to do with either the improper installation of the bridge or the whatever happened that caused the steel beam to drop, correct?
That is not the argument, Your Honor, and that is not what the case law holds. That is, the connection is simply the fact, and that's Regal. That's Regal, the employee had, the injury had nothing to do with his employer's work. It had to do with another employer who created a slippery condition that the employee of Regal slipped on.
Right, but in this contract, right, it uses a specific term as a consequence of the performance or non-performance. So I'm just trying to figure out how just being there doing the work that you're supposed to be doing on behalf of the employee translates to as a consequence of.
Right. That's the thing, Your Honor, and that's what counsel cites and highlights in all his papers as a consequence of, but that's an or in this contract. That's not an and. It's in connection with or as a consequence of. And here, it's in connection with the performance of the work. The connection being the employment, and the performance of the work being providing labor services to my clients. That is what draws the connection there. Specifically, I want to also...
So under your interpretation, they are responsible for any injuries or anything that may happen to their employees so long as they're doing their work pursuant to this
to their employees, not only because of that connection, but also because they specifically assumed that responsibility in the contract under the miscellaneous provisions.
In light of the manner in which this accident happened, wouldn't that result in us reading the word performance out of the indemnification provision?
No, because the performance of the work is providing labor services to the project. That is the whole scope of TSG's work, to provide labor services. And the performance of that work is providing Mr. DeJesus to the project, and the assumption of responsibility for his safety in the contract accounts for the fact that if their workers get injured at the site, they are to indemnify my clients under the contractual terms, Your Honor. If you don't mind, Your Honor, I haven't even touched on the Rockledge issues yet that were brought up against my client. I can do that in rebuttal if you prefer.
I'll give you a minute.
Thank you.
An additional minute.
First of all, to point out, no party here has appealed the dismissal of the claims of Downtown RE Holdings or any issue with respect to them or them being negligent. So if any party here is contractually obligated to indemnify my clients, Downtown is unquestionably entitled to that indemnity. Now, as to Rockledge, there were some points brought up. Specifically, there was mention of this violation, which was written specifically in a way that mentions the fact that the sidewalk shed was not built according to plan. The violation itself says that the OSHA planks, the galvanized steel, was supposed to abut the building face, and it did not. That's what the violation was written for. The original construction of the sidewalk shed by Rockledge. Mr. Medina constructed the shed, left the gap, and then when he saw that it was there, he admitted in his testimony that he knew it was dangerous, so he claims he talked to Mr. Healy. Well, first of all...
Look, why aren't there issues of fact here? The testimony is there, and Mr. Healy is the coordinator of the trades. He has that responsibility. He's the GC. He's fully aware that this 3-foot gap is there. He's coordinating all of the trades, knows when the front of the building is going up, but still okays it to be 3 feet away from the existing structure at the point where the plaintiff is injured. And additionally, he knows and tells them to put plywood up to cover the additional. Why aren't there issues of fact here?
So first of all, Your Honor, Mr. Healy did not say that in his own testimony.
Okay, well, there's going to be questions of fact on that, aren't there?
Well, Mr. Medina's testimony about what Mr. Healy said, I think, first off, is hearsay. Setting that aside, whether it is or is not admissible as hearsay testimony of he said, Mr. Medina
I don't know that
caused
there's
this
any
condition.
he said about the fact that he's the coordinator of the trades and the GC on the project.
Sure, and that's the GC's
And was
general
aware
role, and
of the
that's
gap.
general supervision.
Unless he was somewhere else, he had to be aware of the 3-foot gap that everybody else was aware of that was there.
Well, that's
You're
the thing.
saying
No
he
one,
was not
no one
aware of
else
that.
says they were aware of that, Your Honor. Mr. Nicolia's testimony says he wasn't aware of it, even though he did daily sidewalk inspections as part of his role as the site
It's
safety
remarkable how no one was aware of this 3-foot gap.
Well, when Rockledge put these boards over this gap, there was no more visible light there. So someone who is a non-licensed scaffold rigger looking up would not have seen a gap. They would have
Even a
seen
GC on a
boards.
project.
Absolutely, Your Honor. He's a GC. His role is to coordinate the trades, general oversight. We hire a safety coordinator. We hire a
Thank
licensed
you.
scaffolds contractor.
You have some rebuttal, and the red light is now on for the second time. Thanks very much. Let's see. Next Gen has 2 minutes, I believe. Rockledge, I'm sorry. Rockledge, 2 minutes.
Just very quickly, to address some of the issues that were raised by Next Generation and Noble, everyone keeps saying that that Rockledge didn't build the scaffold to coincide with the plans, but the plans called for the scaffold or the sidewalk bridge to go up against the face of the building. That was the distance. So it did take into consideration the distance which would encompass the face of the building, but the face of the building just was not put up yet by Noble. So they
I
did
don't
do it per the
understand
plans.
how it could be up to the building if there was no building there for it to
No,
be
there
up to.
is a building there, Your Honor. But what happens first is there's the slab.
There are 3 feet, right? There was a 3-foot space. There was a structure. It was not the final structure of the building.
Correct, in the
And
code.
there was 3 feet there so that the structure could be put up.
The 3 feet are there, yes, for the facade.
But the
base
structure
of the
hadn't been
building.
put up.
Just the slab, but the facade
I think
had
we
not been.
understand.
So, but just with saying in that, in next gen, the lower court also too found that with respect to next gen's, the denial of the next gen's motion seeking dismissal of the common law indemnification claim, that at this time, it's an issue of fact for the jury to determine Rockledge as to whether or not they were negligent. So it's,
Thank you.
so they should not, they were correct in denying next generation's motion with respect to that.
Thank you. Next generation?
Yes, Your Honors, I'll be very brief. With respect to the fact that the face of the building was missing, that only goes to my point made earlier that at that point Rockledge should have gone back to their engineer, just as they did after this accident, and said, draw us up some new plans so that we can construct a sidewalk bridge that does conform with the code and is flush against whatever is there, the slab, be it the slab or the face of the building. However, Rockledge did not do that, left the work site, and left the bridge in a dangerous condition, and the accident occurred. I have nothing further. Thank you, Your Honors.
And downtown, you're back up. You asked for 4 minutes. You didn't ask, you asked for 2? Let me just double check.
And I'll be
Yeah,
last.
so I think he was ahead of me, right?
Okay, you did ask for 2, sorry.
May it please the court. In response to the panel's questions of the noble attorney presented an absurd interpretation of the Regal decision and the Worth decision, which is laid out in pages 38 through 39 of the Regal decision. But I'll just read the 2 sentences that matter. This case is factually distinct from Worth. Here, there was a connection between the accident and Regal's work, which means that Regal, in that case, was obligated to provide indemnification, and here it was not. And I would cite to this court's decision in the Arias versus Sanitation case just in 2021, says, in view of the absence of the record of negligence on Lobster's part, the third-party claim for contractual indemnification should be dismissed. The contractual indemnification agreements in this lease between SMHS and Lobster required Lobster to indemnify SMHS for claims arising out of Lobster's acts, omissions, or negligence. They are not triggered by the routine performance of plaintiff's duty on the job as a Lobster employee or his mere presence on the site. I'm not asking this court to apply new law or anything, just to simply comply or reinstate the law it's already stated. And in fact, this case is almost factually identical to what this court decided in Baez versus R&R Contracting, where essentially plaintiff seeks damages for injuries sustained when, while working on a construction site in the employ of the plumbing subcontractor, a beam fell through the ceiling above him and allegedly struck him. Since it is clear as a matter of law that plaintiff's injury was not the result of any negligence on the plumber's part and did not arise out of or result from their performance, summary judgment dismissing that third-party complaint was proper.
Thank you.
Thank you, Your Honors.
Your Honors, with respect to the issues that I am appellant on, I guess is the rebuttal that I have here still, which is with respect to city safety, there was an issue brought up about Mr. Nicolia and what his obligations were, specifically under the contract with my clients. And one of those obligations was to orient workers at the site. He was responsible for intaking the workers, having them give their OSHA cards, taking in all the paperwork. And one thing that he absolutely failed to do as part of his duties under that contract was to identify the fact that Stratford had subcontracted Next Generation to perform the work of Stratford on the site. My client was fully unaware that the workers working for Stratford Steel at the site were next generation workers. And that was Mr. Nicolia's failure when he oriented those workers, identifying that they did not work for Stratford. They worked for next generation. He took their paperwork, he did everything that, he was called for under the contract, specifically written in the contract, orient workers, and that was a failure. And the trigger under that contract is an arising out of trigger, arising out of the performance of the work. That's a failure. That triggers the contract with city safety to indemnify my clients.
Failure to say to Downtown and Noble that the people that were at the site were from next generation, that in and of itself is somehow negligence on the part of city safety?
Well, the fact that Mr. Nicolia didn't orient those workers properly by identifying the fact that they worked for next generation and advising my client, hey, your subcontractor hired a subcontractor. Did you know that? No, we didn't know that. It's absolutely a failure of city safety and its obligations under the contract, not just testimony of Mr. Nicolia. That's in the contract. And he also testified that he performed daily sidewalk shed inspections. That was his responsibility at the site. So that was contracted work, also a failure, also triggering their contract with my clients.
Thank you.
Thank you.
Thank you all.
Thank you, Your Honor.
People versus Demetrius Washington.
Thank you.
May I begin?
Just a moment, please. You may begin.
Thank you. Good afternoon. Benjamin Rutkin-Becker on behalf of Demetrius Washington. This case screams out for reversal of all of Mr. Washington's convictions, but I'd like to specifically address the first-degree gang assault convictions.
So when you say that, I have to ask you, did you have any of those issues been preserved when you say that this calls out for a reversal of all of them?
So there are preserved issues in this case, Your Honor. The ANOA and Confrontation Clause issues are well preserved. The prosecution does not argue otherwise. I will be getting to the charge issue, and that is an exception to the preservation requirement because the court's charge explicitly relieved the prosecution of its duty to prove Mr. Washington's actus reus. That's the Thomas case, which we cite on page 40 of our brief. But in any event, that issue and the other issues in this case are serious enough that they do absolutely warrant reversal, regardless of this court's potential disagreement on preservation. And regarding the gang assault charges, the weight of the evidence does not support these convictions, and they only begin to make sense in light of the court's erroneous instructions on gang assault. Beginning with the evidence, the prosecution's case was indistinguishable for all charges stemming from the June 29th shooting. The only thing linking Mr. Washington to this incident was a single incredible identification of him as the shooter.
Why is it incredible?
Well,
that person didn't seem to equivocate at all when he made that identification. He was near enough to him to make it. I mean, he seemed to know who he was. Why was that?
I agree he was unequivocal. There are myriad problems we point to in our brief with this identification. I won't get into all of them right now, but in broad blushes, we have here, again, a single identification from an individual who's 50 to 60 feet away in the darkness, who claims he can pick out Mr. Washington from a group of upwards 20 teenagers. He lies about the lighting conditions. He fails to identify Mr. Washington by name or description. The first two times he talks to police in this case, it's only after he, quote, asks around on the street that he identifies Mr. Washington. And we have another witness here who is credible, corroborated. She's only 10 feet away, not looking across the park, so to speak, but directly facing the shooter's group, and testifies that she sees an individual in a white t-shirt, indisputably not Mr. Washington, with a gun that night. So this was an incredible identification, and it was rejected by the jury, and rightfully so. We know that the jury rejected this identification because the jury acquitted Mr. Washington.
That doesn't mean that there was an outright rejection of that testimony. It could have been that the jury compromised. It could have been that the jury exercised leniency. It could be a whole host of reasons. And for us to buy into your argument, we have to speculate as to what the jury did.
Not in this case, Your Honor. As a matter of common sense, this was absolutely a rejection of the prosecution's theory, and I'd like to flesh that out in two ways. One, we can all agree this was a horrific, tragic incident. This is not the type of incident that it would be logical for a jury to express leniency. And two, more importantly, this is not a case, there are many cases, for example, where we'll see a manslaughter conviction in place of a murder conviction. The jury here acquitted of murder, manslaughter, attempted murder, and weapons possession. The jury had ample opportunity to express leniency, even if they believed Mr. Washington was the shooter, if that's what they chose to do. And this jury, we know, understood not just physical possession of a firearm, but constructive possession, because this jury convicted Mr. Washington of an unrelated March incident when the gun was indisputably not in his possession. So this jury...
So you're giving the jury a lot of credit with what they understood with regards to the law, and that's a good thing, because isn't it also... can it also be said that they understood the charge with regards to gang assault in the first degree in light of the accessory liability charge?
Right, so I will move on to the charge, and I think that's
You
precise.
should move away from the mic a little bit. It really does. It's a good, it carries. Otherwise, we hear a buzz. Go ahead.
That is precisely the problem here, that if, to the extent the jury understood the charge, that should give this court no confidence in the verdict. Every time the court explained gang assault to the jury, the court did so incorrectly, and under the court's charge that Mr. Washington or, quote, another participant could be the conduct that led to his liability, the jury did not have to find that Mr. Washington did anything. And there can
except that the court did provide the accessory liability charge, which goes against that argument.
It doesn't, Your Honor. We don't dispute that the court provided the accessory liability charge.
And wasn't there a specific jury question about that very issue, and the court answered it in the negative, where the jury asked, is it enough that he was present? And the court said no.
So that actually is not correct. The supplemental jury instructions were in answer to a question regarding the two or more people additionally present element of gang assault. That's what essentially elevates first-degree assault to gang assault. It's the group. The jury was asking about those other people, and actually at the point of the supplemental instruction, as to Mr. Washington, the court repeated the same incorrect instruction that, quote, he or another participant would be, that would be sufficient to find Mr. Washington guilty, not just his conduct. This is an axiomatic principle of criminal law that individuals should only be held to answer for their conduct. This court made very clear in People v. Hill that courts must instruct the jury at a minimum that accessorial liability is the floor for criminal liability. And the problem here is that despite the fact that, yes, the jury was instructed at points about accessorial liability, every single time the jury was told about gang assault, they were presented with an expanded and totally invalid basis to find Mr. Washington.
Is this another one of those questions that wasn't preserved?
So this is what I referenced in your initial question, Justice Renwick. This is, we argue on page 40 of our brief, People v. Thomas, because of the seriousness of this error.
Your answer is it wasn't preserved.
There was no objection to it. It's an exception to the preservation requirement, but even if this court disagrees, it's a very serious error, and we know how serious it is because for all the charges Mr. Washington was acquitted, the jury was properly told that the charges could only be supported by Mr. Washington's conduct as a principal or accomplice. Murder, manslaughter, attempted murder. They're given the proper instructions, and when the jury is given the improper instructions, expanding liability to someone else, that's when they convict on a totally indistinguishable evidence, basically indistinguishable elements. So I'll reserve the remainder of my time for rebuttal.
Thank you. Thank you.
Good afternoon, and may it please the court. Jennifer Westfall for the people.
Counsel, there is, I take it you do not contest that the instruction that the court provided with regards to gang assault in the first degree was erroneous.
I'm sorry, could you?
You do not contest that fact, do you? That the charge that the court delivered on gang assault in the first degree was erroneous?
When you look at the charge as a whole, it was not erroneous.
No, that's not my question. My question is the charge on gang assault in the first degree alone, that was erroneous, correct?
Yes, but accompanied with the accessorial liability
So
charge.
you're saying that the accessorial liability charge and the jury note and the response to the jury note saves it?
Yes. Yes, Your Honor. I would like to note that the jury charge claim now is entirely unpreserved. There was no complaint before, either at the charge conference.
Well, counsel said that, but what he's saying is that this is of such importance that when a jury hears something that's incorrect, they hang on it. And correction didn't necessarily take. What's your response to that?
So I would say that counsel is pointing to 2 times that this was given, but when you look at the charge as a whole with the accessorial liability at the beginning and the supplemental charge at the end, and when you look at in the context of the case, there's no way that the jury convicted without an actus reus. The way that the parties tried the case, the way that they presented the case, argued it, the jury could not have convicted defendant unless he was a shooter or he acted as the accomplice. Specifically, the defense attorney in summation on page 1688 laid out very specifically that defendant had to have done something, and the people made similar arguments in their summation.
Also, isn't your adversary correct in that the way the court delivered the charge, that in essence what the court did was it relieved the people of its burden of proving every element of the crime, namely that he was actually the shooter or an accessory to it?
No, I think when you look at the charge as a whole, that it was correctly given to the jury.
The accessorial charge was a separate charge.
Yes, but it was separate to every single count. It came at the beginning, and then when the jury presented a question about it at the end, with the supplemental charge, which when you look at them all together, presented the correct standard. And the judge explicitly instructed them that mere presence was not enough for gang assault. So there's no way that the jury could have come to that conclusion that he was an accomplice without having acted as one. And that is why preservation is so important here. Clearly, nobody thought these instructions were improper because there was no...
Well, counsel, is that really the case? Because I think the prosecution's theory was that the defendant was the shooter.
We presented both throughout the entirety of the trial.
You presented, with regards to the instance that he was convicted of, you presented evidence that there was another shooter other than the defendant?
We presented evidence that he was either the accomplice or that he was actually the person with his hand on the gun. We argued that...
What was your theory for him being the accomplice?
So he was plainly present with the gang that day. We have the security footage that goes for both theories. The jury also had access to over 2 years of evidence of defendant's active participation in the gang's activities. He actively encouraged his fellow members to commit violence against rival gangs. He participated in the buying of firearms and ammunition.
For you to put forward a theory that he's an accomplice, don't you have to sort of point to who was the shooter?
The evidence that he was there that day with the intent to cause serious physical injury.
No matter who shot?
No matter who shot in that gang.
Even if it wasn't part of his gang?
There was no evidence that there was anybody that possessed a gun that was not a part of his gang.
But there was no evidence of any shooter other than the defendant either, right?
There was evidence that defendant was the shooter.
No, that's not my question. Listen to my question. My question was there any evidence that there was a shooter other than the defendant?
No, there was only a single witness that identified the defendant.
So how does that help your accessory claim?
When you look at the Rikers calls that happened after, defendant never said that he was wrongly charged or that he had no involvement whatsoever. Burton acknowledged that they were both dumb, and she was the one that had the bag with the gun in it. Besides that, Johnson's claims regarding Burton having the bag with the gun and Bunce's sweatshirt were corroborated by other evidence and other witnesses.
Did the jury reject Johnson's testimony in light of the fact that it acquitted the defendant of the possession charge?
We can't speculate about what the jury decided in their deliberative process, and we can't infer anything from the fact that the jury acquitted on other charges. As you mentioned before, they could have been exercising their power of lenity. They could have also decided that when it came to manslaughter and murder that he didn't have the proper intent because Barber wasn't really the target. He wasn't involved in either gang, and he was actually friends with Bunce and Shaw.
Counsel, can you address the excessive sentence claim? You know, this is a first conviction. I think he was like 18 or 19, and the co-defendants received much lower sentences. Can you address that? He's received 40 years.
Yes, I believe defendant was actually in his 20s at the time.
I didn't hear you. Say that last word.
I'm sorry. I believe defendant was actually in his 20s at the time that he killed Barber.
In his 20s or 20?
He was born in 95. It depends on the month. I think he was 20. We are arguing that Justice Wiley's decision in sentencing defendant was appropriate. Defendant was a willing participant in a long-term, multi-year effort to assert control over a neighborhood in which he did not live. Justice Wiley specifically noted that he lived in the Bronx and commuted to West Harlem as if he had made his job just to commit crime.
Counsel, with regards to the criminal possession of a weapon conviction, in that case, the person that actually physically possessed the weapon, that person, I believe, pled guilty and got 5 years, right? The sentence here is 15 for that same charge for a constructive possession charge. Is that not out of line?
I believe that's correct.
I know that you have a red light, but I do have one other question. With regards to the social media posts and the rap lyrics,
Yes.
why wasn't that error to admit that?
Well, it's entirely unpreserved. And, all right. Defendant failed to raise any objections to these errors below, nor did he ever ask the judge to issue any curative instructions to ameliorate that undue prejudice that he now insists requires the reversal of his conviction. Nor should this court exercise its discretionary power to review these belated and meritless complaints in the interest of justice, given the number of complaints.
Were we to review it in the interest of justice, why shouldn't we reverse?
The trial court was never given an opportunity to exercise its discretion, but it is clear that the evidence was properly admitted. It provided a context that was necessary in order to understand the functioning of the gang, including how they interacted, spoke to each other and to
Those
rivals.
lyrics were simply of violence. They spoke nothing about gangs. So how is it relevant to gang activity?
It's relevant to how they spoke to each other and how they interacted with rival members on social media and in the world.
But how does that have to, with regard to the actual activity and whether they perform that activity? The lyrics were extraordinarily violent or expressive in other ways. Why does that mean that they were acting in conformity with the lyrics?
Well, it's the idea that defendant chose those lyrics. That's how he chose to represent himself. And I'm not saying that that means that he did any of those specific lyrics led to any specific incidents. I think only there was one post that was close to the September 5th, but we dismissed those charges.
So by admitting those lyrics, isn't that exactly what you're conveying to the jury?
I'm sorry, I don't understand.
That he's acting in conformity with the lyrics.
No, we presented it, and the prosecutor only ever referred to it as the context of the gang. These were how these people spoke to each other, how they interacted, and how they represented themselves to rivals and to the world. That's the context that was provided to the jury.
What does that have to do with what they actually did? I mean, and whether or not the person who's the shooter is the shooter, and whether or not the person who gives the gun is the person who gives the gun. What does what somebody says have to do with what they actually did on this instance? Because it had nothing to do with what they did on that instance.
Which is why the prosecutor in her summation extensively pointed the jury to the actual evidence of the things that happened that day and told them not to use the rap lyrics as propensity whatsoever. We never used that as propensity.
It's already out there.
I mean, it was 5 posts out of a month, 176 exhibits. Nobody below clearly thought this was a problem because there was no objection. It was used for a context of the gang. It was never used or argued or held out to be any kind of propensity evidence.
Thank you.
Thank you. We ask you to affirm.
Okay, I'm going to move very quickly across a few areas. This is way more than an excessive sentence case, but regarding the sentence, Mr. Washington, 18 and 19 throughout.
Maybe 20.
Sorry?
Maybe 20?
He was not 20.
He was not 20.
He was 18 and 19 throughout the entirety of this. Even if he were 20, I submit that's no difference, but he was 19, to be clear, in light of his first offender status, his age, the acquittals here. This 40-year sentence is outrageous. And I would just point out to your honors that there is a co-defendant.
Do you have a recommended sentence?
Sorry?
Do you have a recommended sentence?
Yes, Your Honor. I was about to continue that. There was a co-defendant here who was accused, and there was strong evidence that he shot an individual multiple times. Mr. Washington was acquitted of ever shooting at anyone. That individual got 10 years. The second highest sentence here is 12 years. Anything beyond 10 years or a maximum of 12 is beyond excessive in this case. Regarding the rap lyrics that Your Honors asked about, it is simply not true that that was just used to contextualize the gang. I'm going to point Your Honors to the prosecutor's summation, page 1762 of the record, 24 of our brief. The prosecutor closes, he's using this in the context of his situation, not only a clever quote, but it is indicative of the conduct that he's actually engaging in. That is an outright propensity argument. It's not just the rap lyrics, it's videos of totally unrelated fights, character evidence that's supposed to indicate to the jury that Mr. Washington is tough or generally violent. His character was never put at issue in this case. So that propensity evidence, we can see it's unpreserved. It was a through line in this case, and it is serious enough to warrant reversal. Finally, regarding the charge, this is a hugely important error in the context of this case. Even if Your Honors decline to find the gang assault convictions against the weight of the evidence, you might not be willing to speculate into what the jury did or didn't do. I mean, at a minimum, we know the jury struggled here. They acquitted Mr. Washington of multiple counts. The accomplice liability case here is non-existent. All the prosecution has is a video that shows 40 people, Mr. Washington amongst 40 teenagers, shortly before the shooting. So if you take out Johnson's testimony that Mr. Washington is the shooter, the prosecution's theory seems to be that any of those 40 teenagers could have been convicted of any of these counts related to June 29th. That is not the law. And so the court's instructions that explicitly told the jury that Mr. Washington could be convicted based on someone else's conduct were tremendously prejudicial in this case, and nothing about the accomplice liability instructions cured them. Again, I would just ask Your Honors to consider, when looking at the charge as a whole, as the prosecution wants here, that for all the charges that the jury received the correct instructions,
Thank you.
they acquitted. Thank you, Your Honors.
Thank you both. Ovalis Sosa versus Lotless.
Good afternoon, Your Honors. My name is Don Sampson. I'm here on behalf of the defendant appellant, the Lot Less store. The facts of the case are very straightforward. The plaintiff walks into the store. She's bending down, looking at purses, and a box falls off an upper shelf and hits her in the head. She blames the store because she said she saw somebody, an employee in the next aisle over stocking shelves, and she says it must be the store's fault. This being a premises liability case, the standard of proof is pretty well established. The plaintiff has to establish that the defendant either created a dangerous condition or had actual or constructive knowledge of a dangerous condition and failed to remedy it. There's no evidence here that the defendant had any notice of any kind of a dangerous condition. So we have to focus on the issue of who created a dangerous condition and what is that dangerous condition. The plaintiff identifies that condition in her brief. She says it's the fact that the box that fell was placed too close to the edge of the shelf. She also says that a customer didn't place it too close to the edge of the shelf. But where she says that in her brief, she doesn't have any record citation. And in fact, there is no evidence of record as to who placed this box that fell too close to the edge of the shelf. The merchandise on the shelves, moreover, was not behind a glass wall. It was accessible. It was the fact is it was individually placed pieces of merchandise. You go into a big box store today, and sometimes you see merchandise on the top shelves in shipping containers or shrink wrapped at the top, obviously not intended to be accessible to a customer. This merchandise was individually placed merchandise.
She has an expert here.
I'm sorry, go ahead.
She has an expert who says that there was a 1-inch cap or something and that just wasn't suitable to prevent it. Why aren't there issues of fact as a result of that?
Well, that's not identified as the dangerous condition here. She says the dangerous condition is placing the box too close to the edge. But even with or without a 1-inch top that went across it, the absence of such a 1-inch guard is not the fact issue here. It's who placed that box too close to the edge. With or without that 1-inch bar that went across, the plaintiff would still have her claim that something was
Well, she
wrong.
said that there was an employee on the other side who was stocking the boxes at the time that one fell on her head.
She says that there was an employee on the other side. She thought it was an employee.
Well, she saw the employee. She went over and saw the employee. She saw the boxes
She walked
shaking, so
around, she
went
saw
over.
what she thought was an employee stocking merchandise, absolutely. Her own
And
expert.
Did she also say that she saw the shelves moving as?
She said that she saw the shelves moving, yes.
As the employee was stocking the shelves on the other side.
Employee was stocking the shelves, and she saw the shelves moving. But the shelves moving were not a dangerous condition. That happens all the time. And in fact, her own expert said, well, we can't confirm that it was the employee on the other side stocking shelves that caused the shelves to move. The plaintiff, in fact, said it could have been a subway car going by. I mean, that's speculation. That's a second area of speculation in this case. The first area is who created this dangerous condition in the first place, i.e.
Who had access to that merchandise?
I'm sorry?
Who had access to the merchandise?
It was
on the shelf that fell.
It was accessible to customers, all customers in the store. Now, if you're asking, it was on an 8-foot high shelf, so obviously short people couldn't reach up that high. Miss Ovalis, my understanding, is relatively short. She couldn't reach up that high, except if she had a cane or an umbrella, she could. 6-foot high customers, I think, could easily reach up 8 feet. If you have a parent with a child, the child could be hoisted up that high. Miss Ovalis herself testified that there were toys next to the box that fell on her. So it's really conceivable that a child is reaching for a toy, the child moves the toy, shifts the box is too close.
Is it also conceivable that the actions of a worker on the other side of the aisle cause the shelves to vibrate and the box to fall from the shelf and strike the plaintiff? Is that also conceivable?
That's also conceivable, but the whole point here, Your Honor, is it's a matter of speculation who caused that box to be placed too close to the shelf. We don't know who caused it, and it's a matter of speculation. And under those circumstances, the defendant is entitled to summary judgment.
Thank you.
And I can rely upon I'm sorry, go ahead.
No, I thought you were done.
We can rely upon the Morales case, the Rosado case, the Mandel case, all First Department cases establish that where it's uncertain and it's a matter of speculation who causes that dangerous condition, the defendant is entitled to summary judgment. We can also rely upon the Third case from the Second Department.
And you have rebuttal time. You'll finish up then.
I'm sorry?
You have rebuttal time. You will finish up
Very
then.
good. Thank you, Your Honor.
Thank you.
Good morning, may it please, good afternoon, may it please the court. On behalf of plaintiff respondent, Ms. Ovalis Sosa. First, I'd just like to point out that the standard that counsel mentions is not the standard in this case. The standard in this case is the standard for summary judgment. There can't be issues of fact. There are so many issues of fact that were just outlined for the court that summary judgment is not appropriate in this case. That's why it was denied. In this case, this is the evidence. My client is bending over.
We understand the facts. She's bending over, a box falls and hits her on her head. She goes around the corner, she sees somebody loading the shelves.
At the same time, the shelf is moving. She goes around the shelf. She sees a person she recognizes to be an employee from the store is stocking the shelf at the same time. As far as who put the boxes there, there's testimony from my client about the photos which show boxes of these vanity mirrors on the top shelf.
Well, couldn't they have been put there by a customer who was looking, took one down, put it back?
All of them in a row on the top shelf?
The one that fell.
Could the one that fell have been put there by a customer? There's no evidence of that. But there is evidence on behalf of, from the testimony of the defendant that this display is how these are displayed, and they're permitted to be displayed in this fashion. And frankly, I just don't see how it could be any more direct based on the testimony. There's someone from the store who caused the accident by shaking the shelf. The merchandise on the other side fell as a result of that. it's fairly direct.
Well, and couldn't there be concurrent causes? The placement of the box, whoever positioned the box in the manner they did, coupled with the vibration of the shelf?
I don't think so. The cases cited in the briefs, I'm not going to go into all of them. I only have a minute. But this is a res ipsa loquitur also absolutely applies to this case. And the exclusivity requirement in res ipsa is relaxed in store cases. I've cited several cases where the same exact thing happened, and the court denied summary judgment, relying on res ipsa.
Thank you.
Thank you.
This is not a res ipsa loquitur case because there was no exclusive possession of the shelving by the defendant here. That's the circumstances for a res ipsa loquitur case. And so as far as the standard for summary judgment is concerned, the Morales case was summary judgment, Rosado was summary judgment, Mandel was summary judgment, so was the third case from the Second Department. All those are summary judgment cases, and each case the court indicated, or the evidence indicated that it was a matter of speculation as to what was the cause of the dangerous condition. And
Thank you.
thank you, Your Honor.
Thank you both. Harry T. versus Lana K., both appeals, 2519 and 3945.
May it please the court, I'm John Verdone and I represent Lana Kay. Lana Kay is a disabled person. She has been diagnosed with major depression, with
Counsel, the issue
anxiety.
here is whether or not that, the magistrate, the support magistrate was incorrect for imputing the income of the mother.
That's correct.
To be, be of a certain amount for a dentist. I think she used the National Bureau of Labor statistics.
That's right, and the magistrate ignored the testimony and report of Deborah Singer, who's a licensed social worker, which my client brought in, not only as her treating therapist, but as her expert.
And how did she err in that fact? How did she err in attributing that amount to the mother based on the National Bureau of Labor statistics? Why was that improper in this case, and wasn't she in the best position to make the determination?
Deborah Singer indicated that my client has disabilities, major depression, anxiety, post-traumatic stress
Counselor,
disorder.
if I may, the social worker, I don't believe she did any independent verification. She just relied on what your client told her. Is that?
That's incorrect, Your Honor. Respectfully, it's incorrect, and the magistrate was incorrect because in her testimony.
Can you point me to the record where she indicated that she conducted an independent verification? Because I thought she said that she relied on what your client told her.
No, it's in her testimony, but also in her report. She submitted a report, written report, and in that report, she indicates that she not only meets with my client once a week for 5 years and observes her during those 5 years, but she
the
also looks
support
at police.
magistrate has the ability to determine credibility and weigh credibility issues.
It's not an issue of credibility. She ignored facts. The facts are that this
She
social
made a
worker.
determination based on those people. First of all, there was no signed affidavit. None of those documents were properly in evidence for the
They're
support
reports.
magistrate to have.
Ms. Singer was there. She testified. She said, yes,
Were
this
they
is my report.
affidavits?
They're not affidavits.
Were they
they're
signed?
Her report.
Were they signed? Were these
She
documents
signed her report, but
signed?
she also was shown the report, and she identified her report and authenticated her report, and her report indicated she's not only.
The court has another question.
No, that's okay. I changed my mind. Okay.
If I may.
I'll let you finish the sentence, so there's
indicated,
nobody else, no opposition here today.
Ms. Singer indicated that she had seen other information, outside information. She had spoken to Dr. Leonard Grice and reviewed his report. She actually spoke with him and reviewed his report, and he had analyzed and assessed my client. In addition, she reviewed police records. She reviewed text messages between my client and her sons. She did an outside investigation. Also, there was a report from Dr. Pfeiffer, a chiropractor, who indicated my client had severe back problems. That was not even mentioned in the decision. That report was admitted into evidence, and there was no objection over that report. That should have been, in addition.
Thank you. Thank you. Parkmerst Investors versus WeWork Companies.
Good afternoon, Your Honors. Paul O'Connor for Appellant Park Merced. This appeal focuses primarily on two errors we submit the trial court made in dismissing this action. Both require just a little bit of background from the complaint and the allegations in it. The case, as the court knows, concerns the financing for the redevelopment of the massive Park Merced apartment complex outside of San Francisco. In 2018, Park Merced had in place a commitment from a third-party lender for hundreds of millions of dollars to fund that redevelopment. WeWork approached Park Merced through its then principal, Adam Newman, to partner and provide the financing instead on much more favorable terms.
But the question is whether this term sheet was an enforceable contract. And it seemed to have a non-binding, indication in the beginning of the term sheet and at the end of the term sheet. So I'm wondering how then it becomes binding based on the contract language itself.
It becomes binding, Your Honor, because on page 95 of the record, it specifically notes that notwithstanding the foregoing, which was the non-binding language, Maximus, GMF, and WeWork acknowledge and agree that the paragraphs caption costs and expenses, confidentiality, attorney's fees, exclusivity, miscellaneous, closing date, and this paragraph shall be binding upon the parties. If you then turn to page 92 of the record, you'll see that under miscellaneous, and this is a binding section, the parties will negotiate the transaction and the documentation in good faith to accomplish the intent of the parties as reflected in this term sheet. And so there is a binding obligation also in here, and I'll find it during the break, in the record for them to fund and close the transaction. That also is binding. So it is true that some provisions in this term sheet are non-binding. Some are expressly binding, and they agreed to that. And the two that are binding, that are most important for our breach of contract claim here, are the obligation to close and fund the transaction and to negotiate in good faith. And look, it makes perfect sense. And this is why I think that the trial court really jumped the gun here. This is a 3211 motion to dismiss decision, and the allegations in the complaint are very clear here. Our client abandoned financing that they had in place upon promises from WeWork that they would provide financing because they desperately needed, as we have in the complaint, Adam Newman said, Park Merced must be mine. And in words or substance, I might be paraphrasing, but that's in the complaint. And the reason that he was doing that was because there was a We Live concept that WeWork had at the time. This is obviously before all the problems that WeWork had that we became aware of, but they had a We Live concept that Adam Newman was trying to push, and he wanted the Park Merced facility in order to do that in it. And so what he did is he came to us and said, look, I'll provide this alternative financing if you back out of the financing that you have now, which we did in reliance on that statement by him. What then happened was they did not negotiate with us in good faith. They did not close, they did not fund, they didn't do anything. As a matter of fact, they really did almost nothing. We sent them documentation, they sent nothing back. So they did not act in compliance. This is, again, what's
And so weren't there liquidated damages if they didn't?
Pardon?
Wasn't there a liquidated damages clause here?
Well, what there is, Your Honor, is a very confusing clause that I don't think is appropriate for resolution on a 3211 motion.
Is it a liquidated damages clause?
What there's an exclusivity provision in here, which we were paid $20 million for exclusive negotiating rights with WeWork. And if you look in there does say that in the event that the transaction doesn't close, we're entitled to keep the $20 million. But what it does not say is that is the sole and exclusive remedy that we have. Liquidated damages clauses, first of all, raise lots of issues of fact, and liquidated damage clauses are enforced very narrowly and strictly. They don't get out of this simply by the fact that they gave us $20 million for exclusivity, which we gave them. We didn't do a deal with anybody else. And the $20 million is there, and the provision is again in the record. And it's under the exclusivity provision, which is on pages 92, 93, and 94 of the record. Again, it's not titled a liquidated damages provision. It does use the words liquidated damages.
Yeah,
but it's in the
doesn't it say
context of
identifies the exclusivity fee as liquidated damages for the very breach? Isn't that part of the language?
I think you might be reading from, I think you might be
I'm
reading
sorry,
from
I'm
the
sorry.
court's decision, Your Honor,
Okay,
but
all right.
that does sound familiar. Look, there's obviously a liquidated damages provision in here, and if you look at, if you look at what WeWork has done in opposition to our papers here, is they have focused almost exclusively on that, because what we know is that while the trial court said that the obligation to negotiate in good faith, they didn't say anything about it, and the obligation to fund and to close, they basically the trial court made a factual determination that they thought that even though it said it was binding, that somehow or another it wasn't binding, because there was non-binding language in the beginning, non-binding language at the end, but binding language in the middle. And again, that this would be binding makes perfect sense. When you think about it in the context, we left behind financing that we had. This would have all been done on the promises of Mr. Newman, who was the principal. He was WeWork. I mean, he basically ran that company, as we all know, and as alleged in the complaint. So my client took his word for it. We abandoned that financing. We tried to work with them to get this financing in place, and it became clear now, after the fact, that they had no intention of moving forward. And I'll save the rest of my time for rebuttal, Your Honor.
Good afternoon, Your Honors. If it please the court, Stephen Meister for the respondent. On page 92 of the record, there is a sentence, the first sentence under the exclusivity clause. It reads, "In consideration of the time and expense to be expended by WeWork and GMF in connection with undertaking due diligence, the preparation of documents and other matters, Maximus," that's the appellant, "agrees that until the earlier of the outside date defined below, and two, the date when WeWork has declined to Maximus to pursue the preferred investment in accordance with this term sheet." So not only is it the case, Justice Renwick, that it's in the beginning of the end, but really throughout this term sheet, there is language which definitively states that this term sheet is non-binding as to the ultimate contractual objective, which was the $450 million preferred equity investment. On Record 87, it's called a non-binding indication of terms. Record 91, there's a reference to later definitive documents. Record 92, we just saw that there's a date when WeWork declines to pursue the transaction.
What about the fact that they should be acting in good faith? I mean, yes, it says it seems, as I said, to say it's non-binding in the beginning. It says that at the end, which goes to whether or not it constitutes an enforceable contract. But what about the aspect of it, parties are supposed to act in good faith?
So if you turn to Record 94, which is the liquidated damages clause Your Honor referenced earlier a moment ago, it says, except as set forth in the immediately preceding sentence, which is irrelevant for present purposes, if the preferred investment fails to close by the outside date for any reason or no reason, or if WeWork fails to timely pay the second installment of the exclusivity fee, which added up to $20 million, then Maximus shall be deemed to have earned an amount equal to the entire exclusivity fee, which again was $20 million, Your Honors, as liquidated damages and not as a penalty, the parties agreeing that the damage to be incurred by Maximus for the failure of the transaction to proceed or to be consummated by the outside date would be difficult to compute. The lower court astutely focused on that dichotomy between failure to proceed and failure to consummate, and adjudged or assessed that the liquidated damages clause both covered the alleged failure to negotiate in good faith, because that's a failure to proceed, or the failure to consummate, which you couldn't have because it's clearly non-binding. In the final provision of the agreement, which is called non-binding, the the term sheet is described as discussion purposes only, not a commitment of agreement or any kind. The terms are indicative, they're not all inclusive, and they're subject to binding definitive documents. In addition, in response to your question about the good faith, there were no concrete allegations of bad faith. There was working behind the scenes. Adam Newman wanted this deal. There's abundant case law in this department and in all the departments that holds that those sort of generic puffery type statements are not sufficient to become actionable. And you can't use a failure to negotiate in good faith to substitute for what is essentially a defective, non-viable breach of contract claim. In short, this contract, look, he says, counsel says that there was a failure or there was an abandonment. It's not true. They kept negotiating with the other side in contravention of the exclusivity covenant, but nevertheless, they were paid $20 million. They didn't have to do that. They could have said, we don't want your $20 million. We're going to stick with the pre-existing offer. They wanted the $20 million. They said, pay us the $20 million. We'll give you 44 days of exclusivity. And you don't have any binding obligation to put up $450 million or anything, but if you don't put up the money, and absent special conditions not relevant for present purposes that require Maximus to refund the money, they're going to keep the $20 million. That's the deal they made. And now, because we were suing them for a refund of the $20 million in a related action, they brought this suit asking for $100 million. There's a $20 million capped liquidated damages clause. That money's in their pocket. And the only parts of this that were really binding were the exclusivity clause and the $20 million in the liquidated damages. The last point I'd like to make is it is important to read. When I was reading the exclusivity clause on Record 92, and I referenced the language, the date when WeWork has declined to Maximus to pursue, which definitively states that the transaction or that the term sheet is non-binding as the ultimate contractual objective. There are two dates: the outside date, which is a defined term, or this declination date, if I may use that term. On the next page, under the section closing date, there is a reference to an outside date of October 31st, 2018. So all they were agreeing to is we'll stop negotiating with this pre-existing party. And by the way, that was a non-binding term sheet as well. And we will negotiate exclusively with you for 44 days until the earlier of October 31st, 2018, or the date you decline the transaction. And if you walk away, we keep your $20 million, okay? There was a predicate refinancing with Natixis for over $1 billion. That was a predicate to the whole transaction. They never closed that, making the transaction impossible. But the point is, they can't sustain any of their claims now. They can't sustain a breach of contract claim. They can't sustain an implied covenant claim, and they can't sustain a promissory estoppel claim. There's no justifiable reliance in the face of the non-binding language. Thank you, Your Honors.
Thank you.
If I could quickly, I think I've got 2 minutes. I would just like to pick up where counsel for WeWork ended, which is, again, on page 95 of the record, the very last sentence of the very last line of this term sheet talks about the fact that they are binding agreements of the parties. And they're not, as Mr. Meister just stated, limited to the testimony that he gave as to what they are. It's the costs and expenses, confidentiality, attorney's fees, exclusivity, miscellaneous, and the closing date. And this paragraph shall be binding agreements of the parties. That's what they agreed. It's an unusual document. That's why it's not appropriate for it to be resolved at a 3211 motion. We should hear from the principals If they want to move for summary judgment, they can, but we should hear from the principals. That should be before the court to make a determination on this. We have an agreement. Mr. Meister can say all he wants, that this is a non-binding agreement. The agreement itself says it's binding. It says binding agreements of the parties. On the issue of the obligation to negotiate in good faith, it is a binding obligation under this agreement, and the trial court did not address the issue at all. The questions as to whether or not the allegations of the complaint are sufficient were not addressed by the trial court. We raised the issue, we argued about it in the oral argument, but it was not addressed by the trial court in the decision. I know the trial court has a lot going on, but nevertheless, the issue was not addressed. That is a key part of it was a key part of our claim. It's a key part of what we agreed to, because we weren't going to drop the financing that we had in place on the promise of WeWork to come in without it being binding on them to fund, to close, and to negotiate with us in good faith to get the documentation done. That's what the complaint says, that's what the contract says, and the trial court didn't address that issue at all. And I would point out, because I said I would, on page 94 of the term sheet, or the record, on page 94 of the record, which is page 8 of the term sheet, under the closing date, which is also a binding agreement of the parties, it says, the preferred investment shall be closed and funded no later than October 31, 2018. That is a binding obligation under the terms of this agreement. We also have a promissory estoppel claim, which the court dismissed by finding again on a 3211 motion that our reliance was not reasonable. Again, I would urge the court to look at that. I don't think it was an appropriate finding at a 3211 motion. The trial court was making a whole bunch of factual determinations at the time that she did that. And I see that the light is on. I appreciate your time.
Thank you. Thank you both. People versus Dominique Francis.
Thank you. Robert Hunter for Mr. Francis. May it please the court. I want to focus on the excessive sentence argument today because there's no question that Mr. Francis's conduct in this case was serious, and I don't want to argue otherwise. I just want to talk about two reasons why the sentence is excessive given his personal situation. Mr. Francis was arrested in the middle of a public mental health crisis. He was dancing in the middle of the street in Times Square in the middle of the night, and this is what he said when he got to the police precinct. I need some help right now. Please, people, please stop aiming guns at the police. Can you stop aiming guns at yourself? Black on black crime, white on white crime, we gotta stop doing it. Later, he asks for a psychiatrist. He asks to talk to a therapist or a psychiatrist because, quote, there's too much stress in America because I see that we're just killing each other. There's so much point going on that we're not loving each other. And he goes on, and these are not the words of somebody who's out there trying to harm someone. It's somebody who is clearly having some sort of crisis. He's obviously paranoid. He's going through a lot of pain. He's just asking for help. And his record shows that he had no contact with the criminal justice system for almost 10 years before this incident happened. He was living a law-abiding life in Philadelphia. He was working. He worked for the city for 3 years.
Also, there was a threat to a police officer here, and in addition to that, there was also I believe, had 3 felony convictions out of the state of Pennsylvania.
Yes, so I'll address the threat to the officer first. I want to read the whole statement here, and this is when he's back at the precinct. And look, I acknowledge that it's bad, it's inappropriate. What he says, when I get out of here, I'm going to get another gun and come back to kill you. I just wanted to see how you'd react to that statement. And so it's a completely inappropriate comment. I concede that. I think it does have to be understood in the context of the hours and hours of speeches that he's making about the sort of crisis he's having. And that combined with the long lack of time without criminal justice involvement shows that I think this wasn't a real sincere attempt or threat to harm anyone. And regarding the 3 Pennsylvania convictions, he pleaded guilty to those in November and December of 2011 when he was 19. He's 31 now. There's no record of any involvement in that intervening time. He was going to college, he was working, he was staying out of trouble, and so it's not completely clear what precipitated the sort of crisis he was having that night, but it's not representative of who Mr. Francis is as a person, and it just asks...
He did have a gun.
I'm sorry?
He did have a gun. He did have a weapon, right?
Yes, he was carrying a gun. And
very dangerously, he drew the gun, right? Or I don't know if that's a fair characterization, but he did something with the gun that caused the officers to unholster their weapons and point it at him, correct?
Correct. So he's in the middle of the street, he's dancing, an officer goes into his car, turns down the volume, and he turns around and walks toward and pulls the gun out of his pocket. At this point, the officers draw their guns, and he throws his to the ground. So again, I'm not defending the choice to carry a gun. I recognize
That's
that
what I'm
it's dangerous.
speaking to, the fact that you're saying he's lived a law-abiding life, but he's carrying an unlicensed loaded weapon.
I understand that the facts here are serious. I just ask that the court consider his record as a whole, his long period without any incidents before this for almost 10 years. And the fact
And counsel, if I may, this sentence resulted from a negotiated plea, right? And the sentence was pretty close to the minimum, correct?
It was a plea. It's a year and a half incarceration over the minimum and 2.5 years post-release supervision. There's a lot of factors that go into the choice to take a plea. I'm not arguing that it was not voluntary. I'm not.
And the court was aware of his background, correct? The court was aware, right?
Yes, the court was aware of the background.
Thank you.
Thank you.
Good afternoon, Your Honors. Carl Dubel for the People. Defendants.
It does seem pretty clear that he was suffering from some episode, something.
Sure, his behavior is very odd, during the time of the incident and afterwards. But there's not.
Wouldn't justice be served with a 3.5-year sentence?
I don't think so, just given the facts of the case, his prior criminal history. But to go back to
His prior criminal history seems to be at least a decade earlier.
True, but he still also has three adult felony convictions. One of them was.
Those are the three that are a decade earlier.
Yes. One of them was for firearm possession, so this is not the first time that he's been illegally carrying a firearm. But to address your question about the mental health issues, outside of what was happening at the scene, there isn't really a record of what the defendant was suffering from.
Well, okay, let's create the picture. It's January 2021. He's in the middle of Times Square at 3 a.m. No one was in the middle of Times Square even at 3 p.m. And he's got his car with the doors open and blasting music, dancing in the middle of the street. I mean, not hurting anybody, but just really bizarre behavior.
Sure.
And then the police, dressed in police uniforms, go to turn off the music in the car and ask him what he's doing. And that's when he draws the weapon or points it or takes it out or does something. They see it either in his waistband or he takes it out. I mean, all of that is a little unusual. And I think he might have pointed it at them because he had it out. I'm not sure. But he didn't. He didn't point it at them. But they take their weapons out, pointed at him, and he says, "Don't shoot me," gets right down to the ground and doesn't do anything and then continues at the police station just with really a rant, just with an incoherent, perhaps, rant. And the one statement in all of those hours that's taken is the one that says, "I'm going to go get a gun and come back and shoot you. I just wanted to see what your reaction would be to that." After constant, is that not someone who, has had seems to have an issue at a time when many people were having issues, and he gets over the minimum for this time in a place that's not really going to help him get any particular
Sure, Your Honor.
psychiatric assistance?
you know, there were other statements, and there are in the record. So I don't want to, you know, hide that. I don't want you.
That had to be the worst.
Yes, of course.
I imagine that's why it was.
But I don't want it to make it seem like the police were ignoring all his other statements and only recorded the one that was actually a threat to them. There is in the
Well, they
voluntary
had to because counsel has them.
Yeah, but I'm
They had
saying
to have
all of his statements at that time are in the voluntary disclosure form, so they're all in the record. But you know, outside of all of this, there was no plea pleading report. In the pre-sentence report, he does self-report some sort of mental health struggles, but again, we don't really know what these are. We don't know what you know, what kind of treatment he was receiving, or if at all.
Is that the reason why we shouldn't address, or why it wasn't addressed, or why we shouldn't consider it? Because all of that behavior doesn't point to.
No, it's of course relevant, and I think that's why he received an almost near minimum in this case. He only the minimum was 3.5. He received 5. All this, of course, was before the sentencing court, and also, you know, this issue was partially litigated in the suppression hearing. You know, defense counsel at the suppression hearing argued that none of his statements were voluntary because of all of these facts, and the court there, you know, found that the statements were voluntary and found that these, you know, outbursts weren't sufficient, or there wasn't enough evidence to show that his statements, you know, weren't voluntary. So, unless Your Honors have any further questions, I would ask that you affirm.
Thank you.
Thanks.
Just two brief points. The government points to the lack of a specific diagnosis in the record here, but I do just want to acknowledge that the fact that Mr. Francis was going through something was acknowledged by probation. They say the defendant would benefit from mental health treatment while incarcerated to address his issues. He also, as we agree, reported receiving treatment in custody. And, you know, to the earlier question about whether all of this information was available to the trial court, you know, the issue of Mr. Francis' mental health was it was raised in the context of the suppression hearing and whether his statements were involuntary, but that's a different set of considerations as to whether, you know, this sentence specifically is appropriate. I don't think the court was necessarily presented squarely with the evidence of his success living out in the community for a long time, and I just ask that you consider that record of success in considering the excessive sentence claim.
Thank you. Thank you both. Barnett versus Berkowitz.
Your Honor, what was the time breakdown for that again? I don't think.
6 and 2 and 6.
I'm sorry?
6, 2, and 6.
6, 2, and 6. Okay, thank you. Your Honor, may it please the court, Howard Fisher of Moses and Singer for appellant defendant Seth Berkowitz. This is a case about a small business, lots of work, years of barely scraping by, and then eventual success. It's a dispute between someone who worked at this company for only a short period of time and the person who built it up over several decades.
But
And
wasn't
most
there an
important-
agreement even though? Wasn't there still an agreement even though, as you've described it, wasn't there, if it was sold, he was supposed to get 6.8% or something of the
Yes,
equity?
the agreement at stake is a June 2006 buyout agreement. And this agreement provided, and this is the relevant part which the trial court didn't address, the agreement provided that Mr. Barnett had a right to 6.8% of the proceeds related to, and I quote, the majority transfer of the equity interests held by the buyer, Mr. Berkowitz, in the company on the date hereof. That is, if Mr. Berkowitz acquired additional equity by purchasing it as grants or by any other means, that would not be subject to the agreement, and the record is clear. The record is also clear that the equity that Mr. Berkowitz had as of the June 2006 agreement went through several different permutations. First, when additional investors came in, it became common and the other investors had preferred interests. Then, when additional investors came in yet again, that common interest became what became known as the subclass B4 interests. In 2015, there was a transaction in which Mr. Berkowitz sold all of his subclass B4 interests. And he wasn't the only one who sold. There were 24 purchasers in this transaction, some of whom were already investors in Insomnia, some of whom were new. Mr. Berkowitz also wasn't the only seller. There were several other sellers at this time, including sellers who had been brought into Insomnia by Mr. Barnett. No one forced anyone to engage in this transaction. No one had a right or an obligation to buy or to sell. This was all freely entered into by 24 buyers and 3 sellers.
Did the buyout agreement define a bona fide third-party purchaser?
Your Honor, this is the secondary issue. The first issue is the fact that as of 2015, there was no equity left that could be subject to the buyout agreement. The second issue is what was a bona fide third-party purchaser. And the agreement, there were plenty of things that could have been done in this agreement. They could have defined third-party bona fide purchasers in a certain way. They could have said, by the way, all of these purchasers need to be completely unaffiliated with Insomnia. They need to be strangers. The sale has to take place pursuant to some auction process or with an investment banker. But they didn't. They simply said bona fide third-party purchasers.
And I want to deal with that because you take the position that the bona fide third party means someone other than the parties here, correct?
Yes, that's the clear reading of the agreement.
All right, but can it also be said that due to the fact that, I believe it was, only the Class A members, right, were allowed to purchase in 2015. So it was like the Class A members and their affiliates.
Mm-hmm.
Can it be said that that really wasn't a bona fide third-party purchaser because they were sort of insiders?
Well, Your Honor, there's several responses to that. The first is that no one was forced to enter into this transaction. This was a transaction between willing buyers and willing sellers. Right. The second response to that is that some of these investors, some of these buyers in this transaction were complete strangers to Insomnia at this time. Some were
I'm glad you said that. Let's stop right there. Strangers. Okay, so you're saying that what I said earlier, you take that as what is a bona fide third-party purchaser. But then stranger, Insomnia. So right now you have 2 different meanings. And the trial court said, both are reasonable. So that's an issue right there.
Your Honor, it isn't an issue because of several reasons. The first, the first and the most primary reason, the foundational reason, is that the agreement between Mr. Berkowitz and Mr. Barnett only related to equity that was held by Mr. Berkowitz at the time of the agreement. As of 2015, all of that equity had been sold. If Mr. Barnett's interpretation is right, then there could never be a liquidation event.
That it changed form?
Mm-hmm. I'm sorry.
Was it that the equity was sold or that it changed form?
It was there were several transactions between 2006 and 2015 where the equity was reclassified. First, all shares were divided into common and preferred, with later investors getting the preferred. After that, what was now common, which was Mr. Berkowitz's interest, became the subclass B4. And it's the B4 interest that were sold in 2015. And as of that date, Mr. Berkowitz's B-class interests, which were the interests he held as of the date of the June 2006 agreement, had all been sold.
Well, so if we were to consider the 2015 transaction to be a liquidation event, he still didn't pay.
That's correct, Your Honor. Mr. Berkowitz did not pay in 2015 when the transaction occurred. But the fact that he did not pay at that time doesn't change the meaning of the contract and doesn't create additional remedies. What Mr. Berkowitz did to remedy his failure to pay in 2015 was to pay the sums he owed to Mr. Barnett into the court in 2018 with 9% interest per year. So to the extent that there is a remedy for Mr. Barnett, that remedy is waiting for him in an account at the court. All he has to do is take it. Thank you.
Thank you.
Good afternoon, Your Honors. Roger Juan Maldonado from Smith, Gambrell, and Russell for Respondent Jared Barnett. Contrary to my adversary's statement, Your Honors got it absolutely right. The concept of bona fide third-party purchaser is key to determination of this appeal. Assuming for argument's sake that the only interests that Seth Berkowitz held as of the date of the buyout agreement constituted the B4 units or interests that he sold in 2015 to Class A members and their affiliates of Insomnia, the lower court, the trial court, posed the following question. She said, isn't it possible that this buyout agreement and its provision as to what triggers a liquidation event can be read in two different ways? One is the way Mr. Berkowitz proposes, which is so long as the B4 units were sold to someone other than Mr. Berkowitz, and it's a little bit absurd to think about him selling the units back to himself, or to Mr. Barnett, and again, why would the buyout agreement prescribe Mr. Barnett buying them back? That's their interpretation of the agreement. And the trial court said, and there's another interpretation of the agreement that I find can reasonably be understood to be correct, and that is that because the interests that were at stake, the value of the retained seller benefit that Jared Barnett held were completely tied to the Insomnia equity that Seth Berkowitz held, that to a sale of that same equity to insiders of Insomnia would not be considered to be a sale to a bona fide third-party purchaser. And it is hard to understand why there is a factual dispute as to the fact that Insomnia insiders are not strangers. It's hard to understand why there's a factual dispute as to why they don't constitute the exact opposite of a third party, as in fact, in a 2016 agreement, they do indicate a difference between non-affiliated third parties and members of the company. But at the very least, there is a genuine dispute as to whether or not the B4 interests were sold in 2015 to third parties. There's also a genuine dispute as to whether that sale constituted a bona fide sale, which is, in essence, the argument that Mr. Berkowitz is making, that he wants to read out of the agreement the concept third party, and he wants you to focus only on bona fide. Well, even as to that aspect, we assert that the valuation at which the B4 units were sold, $62.5 million, was less, substantially less, than an amount that Mr. Berkowitz had rejected or posed to a real third party months before. And that was in the March 2015 back and forth between Mr. Berkowitz, and we are relying only on what Mr. Berkowitz said, which is that at that time, just months before he sold for $62.5 million, that the valuation for Insomnia should be between $70 to $75 million. And that document, which is in supplemental record pages 2 and 3, that document is one that they are contesting as being admissible. First of all, it was produced by Berkowitz in response to a document request, so it carries a presumption of authenticity. More importantly, this will be briefed on motions in limine, where we will demonstrate that the metadata makes absolutely clear that these statements were made by Mr. Berkowitz.
I just have another question. Now, the B1, 2, and 3 units, right? Those were the units that were sold to Krispy Kreme, and they were part of the common membership interests, right?
Our argument is that, yes, the B1s through B3s were also common interests and arose from the same interests that Mr. Berkowitz held prior to, as of the date of the buyout agreement. But even assuming we are wrong on that issue, for the purposes of upholding the lower court's determination to deny the motion for summary judgment, if all that was at stake were the B4 units, and that's all that had to be sold, they weren't sold to a bona fide purchaser because of the amount, nor were they sold to a third party because of who they were sold to. And under the buyout agreement, once those B4 units were in fact transferred to a bona fide third-party purchaser, and that's Krispy Kreme, in 2018, that's when the liquidation event takes place. You don't have to get into whether or not the B1s through B3s were held by Mr. Berkowitz before or afterwards for the purposes of denying or upholding the lower court's denial of summary judgment. All you have to is accept the court's determination that it was reasonable to interpret the buyout agreement to provide as an alternative, not as the only interpretation, as an alternative, that a sale of these key interests to insiders of Insomnia at a price that was contested by Mr. Barnett as being a real fair price, that's a sufficient basis to deny summary judgment. Thank you, Your Honor.
Thank you.
Your Honor, a few responses to the points made by my esteemed adversary. First, as a matter of fact, if the parties wanted to define third party to add additional terms, they could have done that in the agreement. They didn't do that. Secondly, if the crux of the argument made by Mr. Barnett is that in order for this to be a legitimate liquidation event, there had to be people who are third parties to Mr. Berkowitz. Well, there were third parties to Mr. Berkowitz. Many of the people who bought, the 24 separate buyers in the 2015 transaction, were not only foreign to Mr. Berkowitz, they were actually investors that had been brought in by Mr. Barnett. In addition to that, there were investors who weren't already Insomnia investors. There were people who were not already invested in the company who came from outside the company. So if the claim is that in order for this to be a bona fide third-party liquidation event, there had to be investors who were foreign to Insomnia, that requirement, that condition was met. And those foreign buyers, those outsiders, bought at the same price that everyone bought at, and it was a price that the record shows was negotiated. Look at the Berkowitz affidavit, and it's a price that was willingly entered by all of the parties to this transaction. No one forced people to buy, no one forced people to sell, no one forced the outsiders to Insomnia that bought in this offering to complete the transaction.
What is the plain, unambiguous meaning of third party?
The plain unambiguous meaning of third party is someone who is not a party to the transaction, to the agreement at issue. So for the purposes of the 2006 buyout agreement, that would mean that it's not Mr. Berkowitz or not Mr. Barnett. And the reasons for that is clear. The parties wanted to avoid the problem of, say, Mr. Berkowitz incorporating Berkowitz Holdings and selling the shares to Berkowitz Holdings or some other entity completely controlled by him for a price less than what they would have otherwise been sold at. What they otherwise would have been sold at a transaction like the transaction which occurred in 2015, which was freely entered into by 24 separate buyers, many of whom were not already investors in Insomnia. For all of these reasons, the court below erred and summary judgment should have been granted.
Thank you. Thank you both. Sokola versus Weinstein. So have you,
We've worked it out, Your Honor.
and so tell me what you've worked out.
We've decided that the Disney defendants will go first, and then followed by Miramax, and then followed by Mr. Weinstein.
And the amount of time each of you will take, 3 minutes?
We'll each take 3 minutes. We each have 1 minute for rebuttal.
Okay.
Well, good afternoon, Your Honor. Wes Earnhardt on behalf of the Disney defendants, Disney Enterprises, Inc., and the Walt Disney Company. May it please the court. Plaintiff's claim against the Disney defendants fails for 2 independent reasons. First, she doesn't adequately plead that Disney ever employed Harvey Weinstein. Second, she doesn't plead that the alleged assault occurred on or with Disney property. I want to focus on that second element. The starting place is the general rule. The general rule, Your Honors, is that one person, even an employer, is not liable for the intentional torts of another person, even its employees. a narrow exception to that rule exists when an employee commits a tort on the employer's property or with the employee's chattels. That element is fundamental to that exception. The law recognizes a negligent supervision claim only because an employer has a duty to protect others from unsafe conditions if those conditions are created by an employee at work or with something they were given at work. We cite 14 cases that stand for that proposition, Your Honor, dating from the 1880s to 2021.
What was the purpose of that requirement?
The purpose
that it be what we'll call property/chattel. What was the purpose of imposing that requirement?
This tort grew from a premises liability concept, which is an employer should have a duty to third parties only when they have a role in creating the unsafe condition and have the ability to control it. And so
I think that's the key word, control. And so in this instance, Harvey, well, we have a few Weinsteins here. Harvey, the assailant, was controlled, allegedly, in some way, shape, or form by the defendants, right? Allegedly, in deference to you, allegedly was controlled by the defendants.
In some manner, yes, Your Honor. The Court of Appeals in D'Amico directly addressed this question. And the court there, this is a direct quote, "A defendant generally has no duty to control the conduct of third persons so as to prevent them from harming others, even where, as a practical matter, defendant can exercise such control."
And what did they cite for that proposition?
The Court of Appeals cited two cases, Polka versus Edelman, and a treatise from the Yale Law Journal of 1934.
For that particular property/chattel proposition, didn't they cite the restatement second?
They did not, Your Honor. What happens in D'Amico is, in the second part of D'Amico, the Henry part of that case, the court identifies the claim being brought by the plaintiff by reference to the restatement that the plaintiff cites. Having identified the claim by reference to the restatement, it then holds that that claim is limited to torts committed by employees on the premises or chattels of the employer. So it's not...
I'm sorry, just to go to my colleague's question, but D'Amico there was a companion case, Henry, and in Henry, wasn't that where the restatement second was cited?
Henry is where the second restatement cited. It's also where the quotes I just read came from. Your Honor, if I make one more point about D'Amico, plaintiffs allege that there has to be a nexus, then that should be enough. It's hard to imagine a more direct nexus than was alleged in D'Amico. In that case, an employer ordered a drunk employee to go home. The drunk employee on the way home had a traffic accident that killed 3 people. The Court of Appeals said that wasn't enough for there to be a negligent supervision claim because the traffic accident didn't happen on the premises or with the property. If the question was whether there was a nexus, a connection between what the employer did and what the harm caused by the employee, the D'Amico case has a much more connection than is alleged here, but the Court of Appeals rejected that argument.
So, counsel, let's talk about the 3 elements, which are in the PJI, which I have here. However, I don't see anything about chattel. So can you talk about that? Because this is the law, and certainly it doesn't say anything about chattel.
Wait, Your Honor, we have a footnote about this. The jury instructions are not the law. And the reason that
You know, I used to be on the committee, and we did, indicate to the trial judges, when you give instructions on the law.
The law are the decisions of the Court of Appeals. And with respect, Your Honor, the reason that...
I didn't see still that word,
Well, the reason it's not there, Your Honor, is by the time these cases get to trial, because this is an objective test, there is no question about whether a tort, whatever it was, occurred on the premises of the employer or did not. So it's never an issue for trial. And that's the point. The first question is duty. Did the employer owe a duty to the person that was harmed? The only duty that's ever been recognized, unless it was within the scope of employment, is when the harm was happened either on the premises or with the chattels. I'll save my rest of my time for rebuttal.
Pleases the court.
Marvin Putnam of Latham and Watkins on behalf of Miramax Film LLC. I completely agree with my colleague, and I'd like to add 2 small points if I may. One is what was actually alleged in the complaint here. And I think it's terribly important because today in 2023, Harvey Weinstein is a name that will live in infamy and should. When you think of sexual predation, you think of Harvey Weinstein today. But in 2020, when this occurred, that was not the case. So if you look at what actually occurred in the complaint, was that there was a modeling event that Harvey Weinstein went to.
And why did he go there?
No idea.
Can we, all right, let's go based on the allegations in the complaint. Why was he there? Is this because he was an influential and powerful man in the entertainment industry?
I can't tell you, Your Honor, it's not alleged, and I would argue, Your Honor, he wasn't in 2002. That had not yet occurred. And in fact, the court below actually notes that, Your Honor. The court below says, the court finds the allegations here are distinguishable because Weinstein's employment was the predominant, if not sole foundation for plaintiff's encounter with him. Yet there's nothing in the complaint that says that. Instead, what it says is that he went to a modeling event, and if you look at other factors here, he was the principal, investor in Halston. I can go through a million things that have to do with modeling for him that have nothing to do with film, and there is nothing in the complaint that goes to Miramax or film. In fact, he doesn't say he's with Miramax.
Why was the plaintiff interested in interacting with Harvey?
What it says is that she understood, not that he said, she understood by the time she saw him that he could help her with her career.
Modeling career?
Excuse me?
Modeling career?
Doesn't say, because he says, I will help you with your future, is what it alleges there.
But you said he was one, I don't know if you said he was one of the main financiers of the Halston.
He was.
And so that would be someone who was influential.
He also,
in
I agree, Your Honor, but not for Miramax. And in fact, he is never introduced as being with Miramax. He doesn't say he's with the Miramax. She doesn't even know that he's a film producer. And this is important, Your Honor, because when you get to the third element here, which is the idea that there has to be negligence, the idea of control, as Your Honor notes, but there has to be negligence as to that resulted in injury. You can't get that here from a negligence by anything alleged in the complaint, because they don't allege any negligence. As to that third element, all it says was that his employment and that negligence was the proximate cause of the injury here. That is what is said. There is no fact that supports that remotely. So if we allowed this to proceed on that, as the decision does.
This is a 3211, I'm sorry. This is a 3211. It's not a summary judgment motion.
No, sorry.
It's
On a motion
a
to dismiss. Thank you, Your Honor.
sufficiency where we have to look at the pleadings quite liberally and completely in favor of the plaintiff. So,
And does that mean that I don't mean it's somewhat rhetorically, does that mean that that's something where never any indication of any connection to his employer, never any indication as to Miramax at all, means that it proceeds as to them because there is
it
no...
means we look to the complaint. And in this complaint, it seems to name the Disney executives to whom Harvey Weinstein reported at the time and alleged their Disney's oversight and control of Miramax and Weinstein, including that they controlled the budget and the payment and the et cetera, as you know, exists there.
Yeah.
You've read it as well as I.
And I think that's why every decision for the last 100 years that has looked at the third element has gone to whether it happened on the employment premises or with the employer's chattel, because that would be the nexus that would be necessary. Every single one. They don't always use the words. They don't always say premises. They don't always say chattel, but they always look at it. And that's the only way this narrow exception could come into play.
Except the common law seems to have evolved, at least in the eyes of the authors of the restatement. Because now under the restatement third, that coterie is expanded to also include instances where there has been, the employer has facilitated the tortious conduct.
Which seems to me, Your Honor, which obviously the court below mentions, it's the first time that a court has mentioned that in New York, I will note. You'll see no appellate decision that has ever done that. And I think the reason is, Your Honor, facilitate is a term that herein, and even by the court below, has absolutely no definition. Okay, what is to facilitate here? I would argue if it were on the premises or with chattels, it would facilitate. But otherwise, how do you connect an employer to an event that occurs outside of work and without their chattels, their property? Otherwise, what we are saying must occur today is that an employer must overlook everything an employee does outside of work. And I think that's a very dangerous proposition, Your Honor.
Thank you. I think you got lucky because I forgot to press the button.
By the way, I thought that, which is why I excused myself.
Unfortunately for you, I'm pressing the
I
button.
noticed that too, Your Honor. I was hoping you wouldn't have caught that before I
Well, I
came up. May it please the court, Gary Stein for appellant Bob Weinstein. However, the court rules on the premises and property issue, and I agree wholeheartedly with everything my colleague said. The claim against my client, Bob Weinstein, has to be dismissed for an entirely separate and independent reason, which is that plaintiff does not allege that Bob Weinstein was an employer. The only argument that they make against Bob Weinstein on that element is that an individual corporate officer or employee who is not the employer of the tortfeasor and who does not have the power to control the tortfeasor can nevertheless be liable for negligent supervision for quote unquote participating in the employer's tort of negligent supervision. But that's not the law. And I'd like to highlight 3 reasons why why it's not the law. First of all, negligent supervision is a status-based cause of action. It's predicated on the special relationship between an employer and an employee and the employer's power as the employer to control its employees' conduct and prevent harm to third parties. It's just like vicarious liability in that sense, which is also a status-based cause of action against the employer. And that's why this court has said in the Gonzalez case that negligent supervision is a theory of employer liability. It's a specialized tort. Second, the reason why that is the case is because only the employer has a duty to control the conduct of the tortfeasor. And without a duty, of course, there can be no negligence liability. When a corporate officer is held liable for participating in a corporation's own tortious acts, like fraud or whatever it might be, that's because he or she personally owes a duty and breaches a duty to the plaintiff if he engages in that conduct. Negligent supervision is different. Only employers have a duty to third persons to control the conduct of their employees because only employers have the power to control the conduct of their employees. And the complaint here acknowledges that Bob Weinstein did not have that power. You mentioned control, the complaint alleging that the defendants have control. Not as to my client, Your Honor. It alleges, and this is page 45 of the record, paragraph 11 of the complaint, that the corporate employers had the power to hire and fire Harvey Weinstein, set his pay, and control his work conditions. And plaintiff makes no argument that Bob Weinstein satisfies the control test for determining whether someone is an employer. And as a result, he had no duty.
What was the relationship, sir, then, between Bob and Harvey?
Excuse me?
What was the relationship then between
Well, they were brothers. And
the professional relationship.
And they were work colleagues. And importantly here, Your Honor, they were equals. And of course, Bob is the younger brother. And I think it's known that Harvey was sort of the big cojones, if I can use a legal term. But most critically, the relationship did not involve one of control by Bob Weinstein over the conduct of Harvey Weinstein. And that's what makes this cause of action fatally defective.
There are allegations in the complaint that he somehow assisted Harvey in concealing his wrongful acts by not only paying settlements with his own funds, but also having some of these women sign confidentiality agreements and, in essence, failing to rein in Harvey over the course of years. And that's why they assert this course of action against him.
They don't assert that he had control, Your Honor. And that's the test to be an employer. whether he had those things that I mentioned before that are alleged against the corporate employers. Bob Weinstein did not have that power. And yes, there are allegations in the complaint, of course, that he had knowledge of his brother's propensity, and we dispute that. We're not raising that here. But the point is that those allegations, and whatever allegations of whatever conduct he may have engaged in, don't satisfy the employer element, which is a prerequisite for negligent supervision liability. And we cite a case from the Southern District of New York called Fella in our brief, a recent case that makes exactly that point, that the allegations of knowledge of propensity, quote, does not allege an employer-employee relationship between the defendant and the tortfeasor, which is what is required. And think how it's unfair and illogical to hold an individual corporate officer or employee, and it's Bob Weinstein in this case. In other cases, it could be HR personnel, it could be in-house lawyers, to hold them liable for having a duty to rein in or control a tortfeasing employer when they don't have the power to do it. And that's why this complaint is defective, and why numerous, the last point I want to make is that numerous courts in other jurisdictions we cite in the brief, plaintiff doesn't dispute any of them or cite any states that go the other way, hold this very expressly, that only a claim will not lie against an individual, it will lie only against the corporation. And all those states have the same principle that a corporate officer, in the context of other torts, where a corporation's own tortious conduct is in question, that an officer can be, who participates in that can be responsible. That's not unique to New York. It's in Fletcher's Encyclopedia of Corporations. And what that tells you is that negligent supervision is different. There has to be the power to control, the duty control, making the person an employer.
Thank you.
Thank you.
May it please the court, Kevin Mincer for plaintiff respondent Kaya Sokola. Disney, Miramax, and Robert Weinstein knew that Harvey Weinstein had a propensity to sexually assault young women. They didn't fire him, though. They didn't investigate him, and they did nothing to protect the women that Harvey Weinstein met while working. Defendants don't challenge the sufficiency of any of those allegations in the complaint, at least before this court.
Did Robert have the authority to fire Harvey?
That's not in the complaint, Your Honor, that he did have the authority, but what he did have the authority to do is to pay at least 2 women who had made allegations of sexual assault and near rape over £250,000 at that point, something that's around $600,000, out of his own funds in order to protect Harvey Weinstein, to bury those allegations and to make sure no one ever found out about it.
Well, to pay out of his own funds would suggest he was doing it in an individual brotherly capacity as opposed to as a partner or a superior in a corporate entity.
I don't think that that's a fair inference on a 3211 motion, Your Honor. I think that the fact that he is paying this money shows that he is inserting himself in the level of supervision, at least as to this issue. If he is saying that he had no power to control Harvey Weinstein, why is he getting involved and trying to save his brother, his co-chairman of this company, from public exposure, from legal claims, and all of what comes with that? It doesn't make any sense, the idea that he had no ability to stop this. He had every ability to stop this. He affirmatively enabled it and abetted it, and that's the basis of the claim that he participated in the negligent supervision of Harvey Weinstein. The fact that he is not on an org chart, Harvey Weinstein's superior, does not mean that he did not participate in his corporation's tortious behavior.
Well, is that a novel application of that Fletcher principle that a corporate officer is individually liable for the torts of the corporation if the officer participated in the tort? Would that be a novel application of that principle in the negligent retention and supervision context?
It's not, Your Honor. I believe we cite about 7 or 8 cases in which that the individual liability of a corporate officer in a negligent supervision case is applied, and those are New York cases. We didn't need to go out of state to find other authorities because it's regularly done here.
But were those in any of those cases, was the principle applied in a negligent retention and supervision context?
Yes, Your Honor. I think there's about 8 or 9 of them that we cite in a brief. Now, to be clear, at the appellate level, right, the cases that we cite are their negligence cases. Those are not specifically negligent supervision. But my friend for Mr. Weinstein doesn't have a single case at the appellate level either that says that negligent supervision can't be a tort that an individual corporate officer participates in. That is basically an idea that they've made up. That's not anything it's ever been said by this court. We cite many, many cases in our brief that show that that principle is fairly applied to them.
If we could go back to Justice Rodriguez's question about let's focus on what's in the complaint. Other than the payment, Robert's payment to one of the victims, what other allegations do you have in the complaint that would be indicative of Robert's control over Harvey?
Well, in addition, I think, and you pointed it out in your question to counsel, was that not only did he pay for these settlements, but he also made himself, in the settlement agreement, the person who could disclose the information there. In other words, the plaintiffs, the individuals making the claims, they weren't plaintiffs, they were employees, who were bound by this non-disclosure agreement, this silence agreement. The only 2 people under those agreements that were allowed to talk about this were Harvey Weinstein and Robert Weinstein. And so that's another indication that by putting himself in the agreement as the person who could stop this, who could make this public. This was in 1998, Your Honor. We all know what's transpired since then, and it's, this is not, I'm not going out of the complaint. This is all listed in the complaint, the multiple allegations against him. And this is what came in 2002 when my client was assaulted. We all know what comes after that. This all could have been stopped, but Robert Weinstein didn't do that. He abetted it, and he made the silence continue. And that should be the poster child for a participation in a corporate tort. This is the biggest corporate sex scandal, sexual assault scandal, I should say, ever. And this is the person who allowed it to happen. And so the claim against him is very well founded. If I might turn to the chattels and premises argument, Your Honor, because I think that is really foundational. The defendants say that D'Amico, and my friend from representing Disney says that D'Amico imposed such a requirement, but that is not so, okay? D'Amico involved an employee who was fired for intoxication on the job and immediately after being dismissed caused a fatal car accident. The court rejected the plaintiff's argument in the context of that case that Restatement of Second Torts 317 supported a duty of care in those circumstances. But the court did not adopt 317 as the law in New York, and it made no pronouncements about the requirement of a negligent supervision claim. D'Amico would have been an unlikely case for that rule to be adopted because that case involved a tort committed by an employee who had already been dismissed and thus was not under the control of the employer. That's obviously different than what we have here. Moreover,
even if you use the nexus connection.
Yes.
Your opposing counsel says, well, that he didn't have that reputation, didn't have that influence at the time with regard to movies or this or that, and that there's nothing in the complaint that really ties this individual to seeking out Harvey Weinstein for his gravitas in the film industry at that time. That this was a model, and then this was Halston, not Disney.
Yes. So there was a lot of statements by my colleague representing Miramax that totally mischaracterized what the complaint says, and I would ask the court to look at actually what it says and not the characterization. There are numerous paragraphs in the complaint that support the notion that there is a nexus between the defendant's abject failure to supervise Harvey Weinstein and the assault that happened to my client. So being very specific, Ms. Sokolow met Harvey Weinstein at a modeling event, as has been discussed, and when he learned that she wanted to be an actress, and that's what it says in the complaint, okay, he invited her to lunch to discuss her future. That's at paragraph 31. Ms. Sokola knew, it says in the complaint, that Harvey Weinstein was an important American film producer. I believe counsel just said that she didn't say that. That's actually in the complaint to the contrary, and understood the purpose of the lunch was to discuss potential work opportunities at Miramax, on Miramax projects. That's at 33 and 34 of the complaint. Instead of a business lunch, though, Harvey Weinstein used his company-provided phone, his car, and his driver to pick Ms. Sokola up and to take her, without her knowledge or her consent, to his apartment where he sexually assaulted her. And then while abusing Ms. Sokola, he continued to use the power of his employment with Disney and Miramax, threatening Ms. Sokola that she needed to do what he wanted her to do, to work as an actress, and reminding her that he had the power to make her famous as he had with others, who he specifically named, and that's mentioned in the complaint. So these allegations are what would allow a fact finder, and of course we're only at a motion to dismiss stage here, so we're not even at the point of summary judgment, but at a 3211 it's clear that a fact finder could conclude that plaintiff only met with Harvey Weinstein because of his employment with defendants, and he used the prestige, the resources, and yes, also the property of his employers to perpetrate this assault on Ms. Sokola, and that is the basis of the nexus. I would also just point out that counsel's statements that there haven't been any cases that haven't applied that standard in cases that didn't involve premises or chattels is wrong. And we cite several in our briefs. Most recently, Doe versus Intercontinental Hotels, which I believe Justice Kennedy was on the panel, recognized that a plaintiff could proceed on a negligent supervision claim against an employer. It was a security guard who sexually assaulted a plaintiff in a hotel where he had been assigned to work. The employer security guard company did not own the hotel, and there was no suggestion that the assault occurred with the employer's chattels. And still, this court upheld the claim and said it could go forward. In addition to Intercontinental Hotels, I would also refer you to Detone versus Bullet Courier and the Second Department's case in Chuchuca. Now, Detone, to be clear, ultimately went the other way against the plaintiff, but that was because of the failure to show propensity evidence that the employer knew about propensity. There was no chattel of the employer involved in that. It went to trial, and it won at trial. It was only reversed on the basis of the propensity issue, but there's clearly no chattels or premises element, and that case was 1988, 6 months after D'Amico. This is a case that this court is basically foundational of negligent supervision law, and it's completely contrary to what they say.
This cause of action is not new, right? And yet the elements seem to be a little fluid. And so despite D'Amico's language, which has, in fairness to your friends, been quoted several times in the New York federal courts, including the Second Circuit, the elements seem to be elusive to me. So what, in your view, is the controlling authority we should look to as to what the concrete elements are of this cause of action?
Waterbury says what the elements are very clearly, and there's nothing about premises and channels. Gonzalez also says it. Now, Waterbury is a case where they rely on the location of the tort, and Gonzalez is a case with chattels. But the elements of the claim don't provide that is the only way to prove the nexus, right? That's the third element, the nexus. And it just is not the case where that's the only way to prove it. And as Your Honor pointed out, the PJIs don't have chattels or premises as an element. Is it really possible that, according to them, 35 years ago, this was established in D'Amico as an element of the claim, and somehow every judge on the committee who drafts the PJIs became, sort of missed that? That's their position. It's not an element of the claim. The element is nexus, which is essentially a proximate cause issue. And 2 days ago, the Court of Appeals, Chief Justice Wilson, emphasized that proximate cause, and that's in Scurry versus Nietzsche, proximate cause is something that should go to the jury in most cases. It's a fact-bound determination. That's what we have here. Unless the court has any other questions, we'll rest.
Thank you.
Thank you, Your Honors. Look, the allegations against Harvey Weinstein are horrendous. But this is the case where bad facts risk making bad law. There is no appellate decision before D'Amico, in D'Amico, or after D'Amico that allow a negligent supervision claim where the tort wasn't committed on the premises or with the property of the employer. None. What counsel said at the end is really important. The foreseeability and the nexus is a proximate cause issue, not a duty issue. You don't get to proximate cause unless there's a duty. And there's no duty unless it's on the premises or with the chattels.
So the property / chattel element, if it is a proper element, goes to duty, not proximate cause.
Absolutely. And that's exactly what the Court of Appeals said in D'Amico and what court said before that. Until the Court of Appeals changes the rule in D'Amico, that's the law. And the court below and this court should apply the law. What the plaintiffs are saying is that it's a bad law. And that because of the way the world works now and because of what Harvey Weinstein did, policy reasons say the law should be broadened. But that's a question for the legislature. The legislature looked at this. They knew about what Harvey Weinstein did, and they passed the Child Victims Act and they passed the Adult Victims Act. In those acts, they could have removed the premises and chattels element and made clear that employers are liable under these circumstances. They chose not to do it. This court should not second guess that legislative determination. Thank you.
I'll quickly address 3 issues raised by my learning counsel just to show that.
Pressing the button this time.
Don't even laugh. First of all, international hotels, which you were on, Your Honor, actually did address the idea of location. And the idea is the idea in the Restatement 317 Comment B, which goes to the idea that, quote, the premises and chattels element is included because, though in the possession of another, the employer has a privilege of entry, which was the case with the security guard. They had a privilege of entry, therefore it's the same as premises. And that is within the comments for Section 317. 2, in terms of this idea of chattels being within the PGI and otherwise, it's not within the PGI itself, but it is in the comments, Your Honor. And if you look at, which one is it? Perjury, Civil 2240, it says, and this is a quote, the principle upon which liability is based is the same as that involved when an instrumentality, i.e. chattels, is furnished to one not competent to handle it. Okay, it isn't within it, it's the idea of chattels, which goes to the idea that every nexus case, even if they use the word nexus, talks about location or instrumentality. They may not say the term premises and chattels, but if you look at the content, and Waterbury, as he acknowledges, does just that. They talk about it being at the ballet. They talk about those ballet dancers running around thinking they're in a frat and talking and sharing pictures on the phones on location. That is discussed therein. The same is true for Gonzalez, which talks about the gun that he is trained by the police for, and then that is used in the crime because he's allowed to take it home when he shouldn't. Do they use the word chattels? No, it is chattels. That is in every single case where they find it except this one. And then finally, I will note that I did not misrepresent the complaint. I too would invite you to look at it because it doesn't talk about Miramax. It doesn't talk about Disney. At best, what it says is that she understood that this film producer would help her with her career. We really should not change the law. And we did not prepare together, but I will tell you, if I could show it to you, my notes were, when I was in law school 3 decades ago, we were told bad facts make for bad law. Literally what I was going to start with and what I was going to end with. Please don't allow that to happen here, because these are hideous facts. Let's not change 100 years of law.
The allegations that my colleague referenced about Bob Weinstein paying for settlements out of his own funds, not corporate funds, or having the ability to disclose this conduct, or I think he said at one point that Bob Weinstein abetted Harvey Weinstein's conduct, that has nothing to do with whether Bob Weinstein was an employer, whether he had the power and the duty to control Harvey Weinstein's conduct. It has nothing to do with the tort of negligent supervision. These are allegations that, if true, would support a different type of claim. But the fact of the matter is that every single court has rejected a claim of aiding and abetting against Bob Weinstein. In fact, plaintiff didn't even assert a claim here. They did assert a claim of general negligence based on those very same facts, and Justice Tisch rejected it. He dismissed it, and properly so. Why? Because there was no duty. He held correctly, and it's long been the law of this state, there is no duty to prevent a harm to a member of the public, absent a special relationship, like an employer relationship, even where there are factual allegations of the very nature that my colleague described. He said that eight or nine cases apply what Your Honor usefully described as the Fletcher principle in a tort of negligent supervision. Not true. Please look at our brief. There is one case that did that, a Supreme Court decision in a case called Stone. All of the other cases they cite are general negligence or other types of tortious conduct. That was just a misstatement. And as for appellate authority, this court itself said in Gonzalez that negligent supervision is a theory of employer liability, and the Second Department said in a case called Sandra M. v. St. Luke's in our brief that that the tort is based on the defendant's status as an employer. Thank you.
Thank you. Thank you all. Weiss versus Ream Bell. Bell Ream.
Good afternoon, Your Honors. It's Ellen Werther from Ressler & Ressler on behalf of the plaintiff appellant, Adam Weiss and his wholly owned companies. My case is not nearly as interesting as the one that just went before, I promise you.
But it's still important.
It is still very important to me and to my client. And it arises from several factors. One is legal malpractice. The second is the law of secured transactions. And the third is whether or not there should be a dismissal under 3211A1 based upon the mere existence of two unsatisfied judgments. And let me explain. There is a split of authority between the First Department and the Second Department as to whether the existence of an unsatisfied, potentially uncollectible judgment arising from an underlying transaction against the original defaulting party negates any allegation of actual damages, actual ascertainable damages. Second Department says yes, First Department says no. It says so in the Lindenman case, I think it's 2004, and then more recently in 2022. There is no question, and in fact, Lindenman, in the Bazille case in 2022, my colleague advanced the argument, the Second Department argument there, plainly rejected. So what do we have here? We have a motion to dismiss under 3211A1 based upon documentary evidence. There was no documentary evidence that utterly refuted that purportedly utterly refuted the allegations, with the exception of these two judgments. How do I know that? The lower court said so. Nothing else was in admissible form. Nothing else was undisputed. The other documentary evidence was often unsigned, not contemporaneous, couldn't tell who it was from, when it was sent, etc. But you do have the two judgments which self-authenticate. Okay. However, the court said on the basis of these two documents alone, you have not adequately pled ascertainable and actual damages. Now, why would the court below say that? Defendant's counsel urged her to do that. Not once, but throughout the lower court briefs. That is addressed throughout my appellate briefs. In fact, I was shocked when I saw it. I spent a lot of time refuting that. So, in fact, it is throughout the briefs that the defense counsel, the defendants, completely urged the lower court to make that finding. She accepted that invitation against my best efforts, and we submit that it constitutes reversible error on its face. Now let me move on to the next point. Apart from that, the defendants say, well, it should have been dismissed on two legal issues. One, your client, Mr. Weiss, was a, quote, sophisticated investor, a mogul. I think Mr. Weiss would be horrified or quite surprised to know that he'd been characterized as a mogul. There is no fact that suggests that he is, but let's assume he was. Rich people are entitled to have adequate counsel, or at least competent counsel. The mere fact that Mr. Weiss was a businessman who invested in a personal transaction does not make him a, quote, sophisticated investor not entitled to competent counsel. That is essentially the argument that defendants raise. There is no case law directly on point that so holds, and at a minimum, it raises a question of fact. For example, they cite cases where, we discuss it in my brief, but essentially, where there's expert testimony saying that there was no departure, et cetera. The second argument they make is that there is no proximate cause. Why? Because no matter what the lawyers had done, the underlying borrowers would have defaulted. Hello, that's what security interests are for. They're to protect the secured lender in the event that their borrower defaults, runs away with the money, fails to have adequate collateral. That's what they're there for. And security interests may be boring. The UCC can make you fall asleep, but it is there to protect secured lenders. And my client had the right to expect his counsel, who held themselves out as experienced lending counsel, who could protect the interest, he was entitled to rely on them. What happens? First of all, they failed to document the loan in such a way that it gave even basic secured lender protections. Second, they failed to perfect them. What good is it to have a security interest if your lawyer doesn't perfect it? And third, they then failed to timely enforce it. Rather than file the confessed judgments in a timely way, or even the UCC ones, they did nothing. And during that time, the defaulting borrowers ran off with the money. So it is like a cacophony of errors, but who's out in the cold? My client. And with all due respect, these are all questions of fact that need to go forward with a full record before they can be adjudicated. Does the court have any questions?
Thank you.
Thank you. Ben Oxenberg from Furman, Kornfeld, and Brennan on behalf of respondents. If it pleases the court, I'd like to just first address the Lindenman case, because that is what this entire appeal is based on. Lindenman, I don't think I have to tell you what it says. It's clear. Plaintiffs have to plead a cognizable claim, including the value of a lost claim or a lost judgment, and only then can defendants, and only defendants, argue that the judgment was not collectible. So when we read Lindenman together with the decision, there's no conflict. The decision says that there's no need to shift the analysis to collectability because appellants haven't properly stated a claim in the first place, because they received valid and enforceable judgments. And to that point, these are valid and enforceable judgments which Mr. Weiss continues to pursue to this day. He is trying to enforce those judgments. Something else that Mr. Weiss received of value as a result of the way that the respondent structured these loans was that he had full control over 30 Thompson, which is a valuable piece of Soho real estate, worth, by one independent estimate, $17 million. He could have exploited that. He could have gotten his money back that way. He is a sophisticated, experienced investor in real estate with 30 years of experience. Instead, he did nothing with it. He allowed it to go into foreclosure, and it was sold at a fraction of its value. Just, I wanted to circle back to what the decision says, because the appellants sort of, just because it says the word uncollectible, that does not implicate the Lindenman rule. It says, presently unsatisfied judgments are not uncollectible. That is not the same thing as saying, I'm dismissing your case because there's no damages due to uncollectability. So again, there's no conflict there. I don't think anyone would argue that this wasn't the ideal outcome, obviously. The ideal outcome would be he would be repaid on these loans, but it was an expected outcome that Mr. Weiss understood and that respondents had nothing to do with. There's always a risk with any loan that it won't be repaid. And Mr. Weiss,
Were there confessions of judgment and the typical things filed? The things you would expect? Were those things done?
yes,
In a timely
absolutely.
fashion?
I'm sorry. Yes, absolutely. There were confessions of judgment. Those were filed when Mr. Weiss wanted his attorneys to file them. He says in his affidavit now that, the respondents delayed filing these confessions of judgment. Well, that conflicts with a prior affidavit in 2016, which is on pages 565 to 585 of the record, where he says, well, no, it was actually his decision to hold off on filing the confessions of judgment because he wanted to work it out with these co-investors. So that is expressly refuted by his prior statements. And again, these confessions of judgments were filed when they were requested to be filed, and there was a delay in entry, not due to my clients, but just due to the county clerk's backlog. That's also something that he acknowledges in his 2016 affidavit. I just want to touch on the sophisticated client defense, as well as the fact that Mr. Weiss was warned multiple times as to what could happen based on the way that these loans were structured. He was warned that he could lose the $1 million deposit on 9 Minetta in writing, and he responded that he understood, but he was supremely confident in his co-investors' abilities to repay the loans, and if not, they had confessions of judgments. And just one more brief point. It was raised in the appellant's brief, but not in the reply brief. The court below didn't misapply the second department role, which, of course, is different than the first department's role as specified in Lindemann. The Newell case that the lower court cited had nothing to do with the second department collectability rule. It just said that there was no breach of duty and the subject judgment was still valid and enforceable for many years. That is also the case here. These judgments are still valid and enforceable. In fact, they were litigated in the lower, in a different proceeding, and upheld as valid and enforceable. And they will continue to be for another 13 years, I believe. And I see my time is up. Thank you.
I will, by necessity, be brief. Let me turn your attention to what the lower court actually wrote. She actually wrote that here, even if plaintiffs succeed in demonstrating that defendants were negligent, that their negligence was the proximate cause of loss sustained, defendants offer undisputed documentary evidence of the judgments they obtained for plaintiffs in New York and California that utterly refute thereby utterly refuting the element pleaded by plaintiffs of actual ascertainable damages. That the defendants argued that the mere existence of the judgments, although they are undisputably uncollectible, negates any allegation of actual ascertainable damages. On its face, we submit that is clear reversible error. Judge just made a mistake. That's all. First department rule is different than the second. Not only that, I think it is a stretch, at least, to say that my client was, quote, warned of the risks. That's a question of fact, number one. Number two, there are allegations in the complaint and in my client's affidavit which say the defendants absolutely told me, and they assured me, that not only had they filed the confessions of judgment in the correct court, in that case it would have been New York and Suffolk County, but that there was a sheriff's sale underway. He called Suffolk County sheriffs, finds out there not only is there no sheriff's sale underway, that the judgments had never been filed in Suffolk County. Therefore, they could not be enforced. In opposition, the defendants say nothing. So that's why God invented trials, to see whether or not that is true. It is a question of fact, whether or not my client was adequately informed, whether or not the legal services rendered were competent and within the standard of care, And I don't believe it is and it is a question of fact, whether or not, had everything gone forward as planned, whether or not my client would have been paid in full. We submit that he would have been, that the defendants, that the borrower was not have run off with all of the money in secret transactions, arising from, among other things, the failure to perfect and the failure to enforce. Never saw anything like that. Respectfully, we think the lower court made a mistake, and the complaint should be reinstated, and we can go forward with the discovery and trial. Thank you.
Thank you. Thank you both. NW Media versus IBT Media.
Good afternoon, Your Honors. I
afternoon.
always marvel at your stamina at 5 o'clock in the afternoon after listening to this for 3 hours. I'll try to use my
Well,
5 minutes
to a certain
wisely.
degree, we marvel at yours too, because you are still here. So,
Thank you. Robert Weigel, I represent, from Gibson, Dunn & Crutcher, I represent NW Media. NW Media purchased Newsweek from its prior owner, IBT, pursuant to a written contract that was expressly authorized by NW Media's board of directors unanimously. That contract also contains an indemnification provision requiring IBT, which was imminently about to be indicted for bank fraud, to indemnify us for any damage that they caused to Newsweek while they owned it, and also provided that any disputes relating to the contract would be governed by New York law and would be heard in either the federal court in the Southern District or in this court, or in the New York Supreme. The trial court dismissed that action based upon a 3211 motion based on nothing more than a letter that was sent by Mr. Davis, the other director of Newsweek, who also happens to be a 50% owner of IBT. Mr. Pragad, the president of Newsweek, owns 50%, president of NW Media owns 50% of NW Media. Mr. Davis owns the other 50%.
so how many people on the board?
Sorry?
How many people on the board?
There are just two.
Two. So how is he going to get the permission of the board to sue if the other person is not willing to grant that permission? I mean, he didn't get permission of the board. He couldn't.
But, Your Honor, the Court of Appeals, since the Sterling case, 3 times has addressed this very issue. Sterling was in 1949, in Rothman in 57, in Paloma, and in Westview Hills. The 3 cases after Sterling say the following, in some variation, I'm quoting right from Rothman, where there has been no direct prohibition by the board, and there has been none here, then it has been held the president has presumptive authority in the discharge of his duties to defend and prosecute suits in the name of the corporation.
But
that's
Counsel,
quoted in Paloma.
Counsel, excuse me for interrupting you, but didn't Mr. Davis actually object to any lawsuit being filed against IBT before the lawsuit was filed?
First off, there was no board meeting. And in both Paloma and in Rothman, there were objections by the 2 other board members. 50% of the board members in both cases objected. So there was a split board, both in Rothman and in Paloma, and the court made it clear that absent a board meeting and a board vote where people go on the record, it is not disabling. And the court said the same thing in Westview Hills. Absent a provision in the bylaws or action by the board of directors prohibiting the president from defending and instituting suit in the name of and in behalf of the corporation, he must be deemed in the discharge of his duties to have presumptive authority to act.
Isn't that where, though, that the other party is a stranger within the meaning of the authorities? Was IBT considered a stranger here in this?
IBT absolutely was a stranger. IBT is not a director. It's not an officer. It's not a shareholder. In the Sterling case, the Penn Company was, in fact, the person that set up the company. And there are cases Sterling and Tidy House, that both say that you can't actually sue the other director. We couldn't sue Mr. Davis. That was the point he made in his letter. And as a result of that letter, which was sent as furtherance of settlement discussions, but somehow has ended up in the record, that he said, don't sue me. And we did not sue him. That was brought derivatively. What he says in those letters is, we should investigate the claims against IBT. But he is also an interested director. And unlike the case of Sterling, where there was an express authorization for the directors to be interested, or in Crane, where there was similarly a unanimity requirement, the bylaws of this company don't have those sorts of restrictions. They don't have that sort of permission. What the bylaws do say is they have a very broad delegation of authority to the president, broader than even in Rothman, broader than in Crane. The bylaws say the president shall have responsibility for the general management and control of the business and affairs of the company and shall perform all duties and have all powers which are commonly incident to the office of chief executive. There's no unanimity requirement. There's no...
So don't the bylaws also say in Article 3, Section 8, that the business of the corporation shall be managed by its board of directors, and that a vote of the majority of the board of directors present at the time, et cetera, et cetera? Doesn't that serve to curtail any presumptive power?
It does in the sense that if you have the board of directors can always say, they can have a vote, and they can say, stop. The board of directors can override the president. The question is here, as in Paloma, there was advance authority to the president to do this. And if I might indulge, I see my time is late, and I know, but the question presented in Paloma is right there in the first paragraph of the decision. The question for decision is, when a contract between two corporations includes a general arbitration clause, may the president of one contracting party, without specific authorization from his directors, commence an arbitration of an alleged dispute when half of the directors of his corporation represent the other contracting party on his corporation's board and presumably would not vote in favor of bringing this dispute before the arbitrators. Now, apart from the fact that this is an arbitration and we are a lawsuit, this is exactly Paloma, and what the Court of Appeals held in that case was that because they had approved the contract, and because in that case it had an arbitration provision, in our case it has a choice of law and a direction to go to this court, that there was advance authority by approving the contract that if there were a dispute, that you could bring the suit. And to Your Honor's point, the question really is, that was approved. If there's a split, can Mr. Davis unilaterally remove that approval? And I would submit the answer is no. There's one other fact I need to mention to the court. I would be remiss.
Why don't you mention it on rebuttal?
I will do. Well, I would like my adversary to be able to say it. Could I just half a second? Mr. Davis has, my understanding is Mr. Davis no longer owns any portion of the IBT, that he is a complete stranger to the company at this point in time. And that has happened recently after all the briefing. My adversary can confirm it.
That's the record then, really.
It is not part of the record, Your Honor.
I don't want you to respond because it's not part of the record. We won't take it into consideration.
Good evening. Ryan Philp from Hogan Lovells on behalf of IBT Media. May it please the court. I'm glad Your Honor concluded with that comment because that in fact would have been my first point, that it's outside the record. And in any case, what controls was the facts at the time of Mr. Davis's objection. To frame the facts, going to Your Honor's question, it's important to talk about what the parties chose when they formed NW Media. This is a true 50-50 governed corporation. The bylaws, consonant with New York law, which prizes the primacy of board governance, states that the corporation will be governed by the board. Mr. Davis and Mr. Pagad chose to be half of that board, 2 members. Likewise, they each own 50% of the shares. The bylaws state that at the board level and at the shareholder level, majority controls. That is unanimity. It provides each shareholder, each board member with a blocking right. Now,
But was there a vote here?
there was no vote. However, there is no requirement in the case law, contrary to what opposing counsel has advanced, that there must be. The question that's posed is a question of authority. The board governs the corporation. There is implied residual authority that exists in a president as a function of necessity, that a president must be able to conduct the day-to-day affairs in the ordinary course of business. However, there is no dispute that that authority can be divested, and that is exactly what happened in Sterling. The only answer to Sterling, there's no dispute that it controls, the only answer to Sterling that has been posed is there is no formal board vote. But as opposing counsel indicated, the case law does not articulate a bright line rule that requires a board vote or a bylaw. What it requires is a direct prohibition. And what they would like to ignore is the letters. I've heard that there was an objection in Rothman, there was an objection in Paloma. Not so, not prior to the initiation of the lawsuit. And what we need to do here is look at those letters. Not only does 50% of the shares, 50% of the board clearly articulate to the corporation that there is authority lacking at all levels, he also requests a special directors meeting. He invokes his powers as a director, formally requesting a meeting. To hold that formal objection, there's nothing else he could have done, is insufficient to divest residual authority, implied authority in the president, turns principles of New York corporate governance on its head, and it disregards the bylaws because it says that the president is the tiebreaker, which is exactly what Sterling says is not the case, and it invites pernicious conduct because what it suggests is even if there is a formal request for a board meeting, I can circumvent it by running to the court. And again, that is utterly contrary to New York principles of corporate governance and to the bylaws that these parties signed. And I think it bears particular emphasis how difficult and contrary that rule would be to 50-50 governance, where New York courts have expressly recognized that parties are entitled to choose the possibility of that deadlock. New York law does not create a deadlock breaker, nor did they prescribe one in the bylaws. And so to the extent that there are 50-50 corporations, effectively what we would be holding here is notwithstanding in advance express objection and a request for a board meeting, that the president can circumvent all of it by running to court. And I would submit to you that's not the law, and it should not be the law. And just the last point with respect to all of the authorities that have been cited by opposing counsel and by NW Media, they all relate to circumstances where a president retains authority in the face of a belief, a knowledge that were it presented to the board, it may create board deadlock. Perhaps it's even certain to understand that it would create board deadlock. But none of them involve what we have here. And the trial court recognized that in dismissing, specifically recognized that what we had was a formal objection set forth and directed both to in-house counsel and outside counsel and to the corporation itself, saying that no authority existed and requesting a board meeting. And so we would submit that that controls.
Thank you.
I will be brief. In the Paloma case, the court distinguishes Sterling. The first such difference is this. Sterling's president asked his board's permission to bring the suit, but there was a tie vote, which this court treated as a refusal by the directors of permission and its analysis. A more important difference between the case is that the president is merely carrying out an existing agreement. There was no discussion by my colleague of the fact that they had approved this sale contract, that this sale contract had an indemnification provision, that had they wanted to require both parties to agree, because Mr. Davis was, at the time, an interested director because he had a direct pecuniary interest in whether or not IBT got sued. So it's not a unanimous requirement because he couldn't vote. And unlike Crane, which had a unanimous requirement in the bylaws, and unlike Sterling, which had a provision that expressly allowed for an interested director to vote, there is no such provision in this action. And I would just point out that in Rothman, this is not a question. The Court of Appeals says an affidavit by Rothman in support of the application recited that he did not believe the action had any merit. Neither he nor his wife desired to have it prosecuted. Those are the two directors who were two of the four directors. They submitted an affidavit in the case saying we oppose. And Rothman still said the president has presumptive authority without a board vote. The question is, was there a board vote or not? And I realize that that is perhaps a precise distinction, but is one made by the Court of Appeals twice, in Paloma and in Rothman. If there's not a board vote, then there is no basis for saying that there is a deadlock. And this was done on 3211, and we would ask that it be reversed. Thank you, Your Honors.
Thank you. People versus Luis Medina.
Good afternoon. Daniel Hamburg with the Center for Appellate Litigation on behalf of Appellant Luis Medina. The prosecution's rationales for striking the only two African-American jurors in the first panel during voir dire were pretext for racial discrimination. The reasons cited, including the black jurors' high school education, the nature or the status of their employment, the lack of life experience, and one of their living arrangements, all amounted to the preposterous proposition previously rejected by this court in People v. Murray that only jurors with higher level jobs or similarly education can perform the basic function of jury service, and in this case were proxies for race. These rationales were not sufficiently related to the factual circumstances of the case in order for the court to credit them as genuinely race neutral. This was an assault on the street that was captured on surveillance video where identity was conceded. The facts and the legal issues were limited. The only issues that the jury was asked to decide were Mr. Medina's intent and whether the assault came dangerously close to causing serious physical injury. Under these circumstances, there is simply no reason to believe that a college education or a white-collar job was necessary in order to understand the facts and apply the law. Turning briefly to the other reasons cited by the prosecution for striking the two black jurors in this case, the prosecution at one point states that it was difficult to understand Mr. Taiwa, but jurisdictions around the country have recognized that rationales rooted in a juror's supposed deficiencies in articulation or communication ability are exactly the type of demeanor evidence that courts have recognized invites implicit bias into the jury selection process and should be rejected. Moreover, the record simply does not support that the prosecutor or court, in fact, had difficulty understanding Mr. Taiwa. In the course of...
Didn't the court make some comment with regards to the court didn't know how the court reporter took down what the juror said? Something to that effect.
After denying defense counsel's Batson challenge, the court did make that comment as an afterthought. However, the transcript cleanly memorialized the juror's statements, and moreover, the judge was able to have a colloquy with this juror in the course of the questionnaire beyond just the juror's answers to the standard questions. The court actually followed up with him beyond that and had an exchange where clearly this juror was able to be understood. Furthermore, the prosecution, in the course of listing their rationales for striking this juror, ticked down all of the answers that this juror gave in the course of the questionnaire, belied the idea that this juror was difficult to be understood. And then turning to the separate rationale proffered for striking the other black juror, Ms. Peterson, the prosecution asserted that they struck this juror in part because she answered to the court's questionnaire that she had a relative with a criminal conviction. This court has previously recognized that rationales rooted in a person's experiences, or more so even their family members, with the justice system, similar to this one, are suspect because they tend to disproportionately exclude black jurors. And in this situation, I'm referring to the case People v. Watson. It was a slightly different context there, but the same principle, I think, should be applied in this situation. And furthermore, the record amply demonstrates that this reason was pretextual. The prosecution had no problem seating a white juror who said he had a cousin with a misdemeanor conviction in Connecticut, and also the prosecution did not strike a white juror during the selections of the alternates who mentioned that she had family members with criminal convictions. There were no this juror, the one that was struck, said that her family member's criminal conviction would not affect her ability to be fair and impartial, and her other answers indicated that she was likely to have a tendency to be favorable towards the prosecution, as she had friends that were studying to join law enforcement, including one seeking credentials to become a detective. Before my time is up, I do want to turn briefly to Mr. Medina's excessive sentence of 10 years, which was twice the pretrial offer. While Mr. Medina's conduct was undoubtedly serious, in focusing exclusively on the need for specific deterrence, the court ignored Mr. Medina's excellent potential for rehabilitation. Despite, just backing up for a second, Mr. Medina, at the time of this offense, was in his mid-30s and had only one previous criminal conviction from 18 years prior for burglary in the third degree. There was no indication that he had any previous violent conduct or contacts with the criminal justice system for violent conduct. And despite his mental health issues, which were clearly recognized, the 390 exam reflected that when Mr. Medina was in the shelter system and receiving services, he was working and he was managing his mental health conditions. And in light of the services that he will receive through parole and be mandated to comply with, there's every reason to think that he will be successfully rehabilitated, and 10 years was simply an excessive sentence. And given that the court recognized that this offense was an aberration brought on by Mr. Medina's, by a mental health crisis, the sentence was excessive, and I would ask this court to reduce it.
May it please the court, Amanda Regan on behalf of the people. The lower court properly denied defendant's Batson challenge, and this court should affirm that decision for two separate reasons. First of all of defendant's Batson claims are unpreserved, and therefore the record is not full enough there was no follow-up by the court because defense counsel didn't elaborate why he thought that the people's proffered reasons were pretextual. When invited to do so, he simply said, I disagree that somebody with a high school education couldn't understand the medical records. The court said, would you like to say anything further? And he said no. So everything that defendant is raising here on appeal is unpreserved. And the second reason that...
Did the prosecution strike any white jurors who only had like a high school education?
Yes, Your Honor. In fact, the people were engaging in a clear strategy of selecting the jurors that they felt were best for this case, and that included striking any juror who had only a high school education, regardless of race.
So this is a criminal case where the person slashed somebody
Repeatedly,
multiple
yes.
times, and that was something that a high school educated individual wouldn't be able to comprehend?
Well, it was clear from pretrial conversations that the basis of defendant's defense was going to be challenging the medical records and bringing in a defense expert who would be testifying about those medical records. And
That's the purpose of a medical expert. You only get it when you feel that there's something beyond the ken of the juror, even a college-educated juror. Otherwise, you wouldn't need that expert.
Understood, Your Honor, but here there's no evidence because the people were engaging in a pattern of striking anybody with just a high school education, regardless of race. There's no pattern of racial discrimination on that basis. And there similarly, the people were also striking regardless of race anybody who was unemployed at the time. I'd point Your Honors to...
So there was no high school, there was no one on that jury at the end of the 12 who only had a high school education.
No, but Your Honor, that's not the cognizable group that the defendant has, alleged is the basis of their Batson claim. Their Batson claim was that there were 2 African-American jurors who were struck, but here we have the people striking anybody with just a high school education and anybody who is unemployed. That does not survive a Batson claim. And
that's my question. Are you saying that there is no one on that jury? There was no one on the jury who had only a high school education?
No, there was not, Your Honor.
Everyone else had something higher than a high school education?
Yes, every juror that was selected had at least a college degree. Many had advanced degrees.
That to me is a sad statement, but it's not part of this case.
No, it's not, Your Honor.
That a prosecutor should, on a basic criminal action, strike every high school educated person under the guise that, whatever you want to call it, an explanation that they just are not competent enough.
It's not that they're not competent enough. It's that, and this goes to what the prosecutor's explanation, part of the prosecutor's explanation was, but perhaps they lack, especially in the case of Ms. Peterson, she was only 19 years old. She lacked the maturity and the life experience to effectively deliberate with the other jurors.
She went through high school, right?
She went through high school, but...
She was working?
She was working as a waitress.
That sounds like a job that really requires interaction with people, so I don't understand.
Absolutely, and I'm not discrediting that, but my point being that young people in particular, and this was also a basis of the People's Challenge below, they lack maturity and life experience to deliberate with.
You're right. They can go to war at 18, but they can't sit on a jury because they just wouldn't understand it. But I'm going far afield. Why don't you?
Thank you, Your Honor. There is ample case law, as cited in our briefs on page 30 and 31, that support the same bases that the people gave below as finding that they were non-pretextual. And I'd just briefly like to touch on this court's case in Murray. That decision is different than the factors here because there was a proper record, it was preserved.
Yeah, because they didn't take everybody who had a high school education off. This, I don't know what they were after here, but that might be the only thing that saves this. But
well,
I don't
Your Honor,
understand it. It really is interesting. But.
And that's why preservation is so important here, Your Honor. There's not sufficient factual record developed below. And certainly, counsel was given ample opportunity to make that record below, and he did not do so. And Murray is distinguishable because the issues were preserved. And I'd also like to point out that in Murray, one of the 2 challenged jurors that this court found that the people's reason was not pretextual was that a family member of his, and I'm discussing specifically Mr. Israel, was convicted of a crime. So there is case law to support that that is a proper non-pretextual reason. I know that there are other issues raised in the brief. Unless your honors have any questions on those issues, we would ask that you affirm.
All of the reasons that the people just cited here to ask the court to affirm the lower court's decisions, I think actually further defenses Mr. Mr. Medina's argument that these were pretextual. First of all, with respect,
And also that if one objects, not you, but if defense counsel objects, then they preserve it, then they're able to make a solid basis, then they can, right?
well,
We have a record.
that was going to be my first point, which is that on this specific point, the issue of whether or not the prosecution's proffered rationale regarding these jurors' high school educations was a legitimately race-neutral reason, defense counsel did preserve that very clearly. He stated, I dispute that that is a legitimate reason because one does not need a college education in order to understand the testimony regarding the medical records.
But no one, I'll ask it. You go.
Sir, is your friend correct that there were no members of the jury who only had a high school education?
It is correct that the prosecution did strike every juror who had only attained a high school education. However, I would say that...
And just to interrupt, those were blacks, whites, and others?
So...
They weren't just blacks. They weren't just black individuals. Is that true?
As far as I can tell, the only two jurors from the first panel who only had high school education were the two black jurors that were struck. There was another juror in the second panel of voir dire that was struck who only had a high school education. I do not know the race
Well, I
of that
guess this is
juror.
where the preservation point is important because we cannot tell the race of an individual based on their name. And so if a record is made, then we could evaluate, the judge could evaluate, and then we could evaluate or test the accuracy of that statement, that the type of reason used for the peremptories, whether it was advisable or not, was used across the board.
Yes, Your Honor. However, if I may, I want to say that that should not be the court's only consideration. Case law is very clear that these types of rationales regarding employment, regarding education, have to be sufficiently tethered to the factual circumstances of the case in order to be credited as sufficiently race neutral. So even though there is this comparison issue, I don't think that the court should not credit this rationale in the first instance. And with regard to the young juror that was struck due to her supposed lack of maturity and ability to deliberate with her fellow jurors, I find that reason is extremely suspect in light of the fact that the prosecution did not strike several jurors who were her contemporaries, who were maybe a year or two older, but who happened to have college education. And as far as the employment point, there was no evidence that the employment status of Mr. Medina was going to come into effect in the course of the case. So I don't believe that this is a legitimate reason, as this court has held in People v. Jackson.
Thank you. Thank you both. Wu versus Uber Technologies.
You're doing your pro hoc first. Would you like me to move his application to pro hoc now or after?
Yes, now would be a good time.
May it please the court, good afternoon, good evening, wherever we are. Jacob Tabor of Perkins Coie for respondent Uber Technologies, Inc., here to present Michael Houston of the Bar of the District of Columbia and ask that he be permitted to argue the appeal.
It's granted. You may inquire.
I guess I should say good evening, Your Honors. I know this has been an unusually long day of argument, and thank you for the chance to be heard. May it please the court, my name is Joshua Kellner, and I represent the plaintiff appellant Emily Wu. We've spilled a lot of ink in this case, I don't deny that.
But at its core, it's about a very simple principle, and that is the integrity of the judicial process itself. When a litigant retains a lawyer and starts a lawsuit, they have the right to expect that further dealings on that lawsuit will be directed to their lawyer, and the matter will be adjudicated through the courts. In this case, what Uber sought to do was systematically circumvent represented parties, attorneys in pending actions for the purpose of obtaining a benefit it could never have gotten had it gone through proper channels and dealt with attorneys. Uber cites more than 100 cases in their brief, most of which relate to arbitration. Not a single one of them blessed an arbitration clause such as this one, presented to a represented party in a pending case designed to gain an advantage without talking to their lawyer. This court should not be the first court to bless an arbitration clause such as that one, and it should not countenance the violation of the no contact rule that Uber committed here.
What is the normal remedy for a violation of the no contact rule?
I'd say that there are two possibilities, Your Honor. First, there are many cases that say that you don't get the benefit of the labors, that whatever it is, it makes it unenforceable. That happened in Berkson, which everybody cites in their brief, and we talk about for that point. It happened in several other cases as well, which we cite in our reply. It also goes to the inherent authority of the court to sanction parties for ethical violations. Because the idea whenever a court is considering sanctions is not just how do we deal with this case, it's how do we deter it in the future. And Uber's pattern of conduct in this case says that a deterrent is warranted. Because it's not just one case, it's not just Emily Wu, it's a systematic effort to circumvent parties' lawyers. And remember, when we're talking about a contract, they don't deny that their intention was to reach pending cases and to sweep them into arbitration once they had been brought and once they knew that people were represented. So it's difficult for me to fathom an instance where a strong deterrent is more warranted than in a case like this one. If I might, and before we go farther, I'd just like to address the Brooks case, which Justice Rodriguez, I know Your Honor, sat on, and which the respondents submitted after it was handed down, but obviously after all the briefing was done. Obviously, we would have preferred to go a month earlier rather than a month later. But at the same time, the case is readily distinguishable. First, the Brooks case made very clear at the outset that the alleged agreement there was entered, quote, prior to the commencement of the instant action. So there you have—
That's a major difference between that case and this case.
I'm sorry, Your Honor?
That's a major difference between the two cases.
Oh, absolutely. It's night and day, because I think, as everybody can see from all the briefing in this case, the key issue here is this is conduct that was done once the case already was pending and after they knew that Emily Wu was represented.
So although that is a major difference between the two cases, I mean, what is similar is that they both involve the same clip agreement, and that there was notice, right? There was at least inquiry notice.
I'm sorry, I just missed the last one.
There was at least inquiry notice.
I think that the distinction between the two cases goes fundamentally to whether there was inquiry notice. This court in Brooks did not accept the test that Uber is urging here. What Uber says in its brief here, and I'm quoting, is all that is required is that the user be given a sufficient opportunity to read the agreement. But what the Brooks court said is we need to look to the reasonableness of notice. And courts around the country, when they've considered whether notice was reasonable, they've looked to whether there was a sufficient warning as to adverse terms to the consumer, or to look at what the Massachusetts Supreme Court said in Cowders, whether there was notice of the contents of the terms. So in that case, with a prospective arbitration clause, meaning a case that hadn't been brought, we can debate, and I know that the Brooks court spoke to whether there was sufficient notice. But here, in this case, there's clearly no notice whatsoever to a represented party with a pending action that that's going to be swept in. You have the email in the dialog box, which say that it's an update that will go into effect on a future date. You have no mention of pending lawsuits. And then even if you go into the terms of use, which a represented party should never have to do, and look at the capitalized language that they cite in their brief as a warning, what that said is that this affects how cases or claims between you and Uber, it says claims, quote, can be brought. Can be brought is purely prospective, and nobody, not even an attorney, would look at that and say that relates to a lawsuit that's already pending in the court, where you're represented by an attorney, and where based on anybody's understanding of the legal system, you have a right to expect that this will be addressed to your attorney. So there's not appropriate notice here, given both the overall structure of what was presented to her, and particularly even wading into the weeds of the language that they gave her. I want to talk a little bit about the ex parte no contact rule and as it relates to this case. I know my time is dwindling. First, they knew that she was represented. We adduced a proper affidavit of service. All they had in response were conclusory assertions, which, to the extent that we consider them at all, were affirmatively contradicted by substantial evidence. It's clearly inadequate under this court's case law. Second, it's equally clear that lawyers caused the communication to be sent. They have a very artfully worded affidavit from a paralegal in Indiana, and all he said is that the email was sent by the operations team. So they don't deny that a lawyer drafted it, piloted it, directed it, and that's particularly clear with a company like Uber that, as we can all see, has access to the most sophisticated legal minds in the country. There's no doubt this was piloted by lawyers. They recognize that Rule 4.2 applies to pending actions, even in the class action context, and the court should not countenance what happens here. Thank you.
Thank you.
May it please the court, I'm Michael Houston of Perkins Coie on behalf of the respondent, the Uber entities. I want to make 4 points this afternoon, Your Honors. The first is that there was nothing retroactive, there was nothing sneaky, there was nothing deceptive that happened in this case. Ms. Wu agreed to arbitrate all claims, all disputes that she had with Uber back in 2016 when she signed up for an Uber account. That is not the same interface that was at issue in Brooks, but on the principles of law that this court articulated in Brooks, especially its adoption of the reasoning of the Second Circuit in Meyer, it is clear that the interface, the similar, it's slightly different, but the similar interface that Uber used in 2016 to provide the plaintiff with the knowledge of the existence of these terms gave rise to an enforceable agreement. That interface is in the record at page 291, and I would really encourage the court to look at it because I think it makes clear that contrary to my friend's suggestion, this interface was more than sufficient to call to the user's attention the existence of the additional terms.
Was the arbitration provision in 2016, was that limited to claims relating to the terms, or was that more broad and it included all claims as the newer 2021 arbitration provision stated?
I think it was certainly broader than that, Your Honor. The terms that she agreed to in 2016 are at page 242 in the record. They say, you agree that any dispute, claim, or controversy arising out of or relating to these terms or the use of the services. So I think this is fundamentally her claim here is about her use of the services. She alleges that there was negligence in connection with Uber's provision of the services.
Did she accept the 2016 arbitration provision through a click-wrap agreement?
She accepted, not through a click-wrap agreement, Your Honor, but through what is sometimes called a sign-in wrap or a hybrid wrap agreement where she had to register.
Those are not looked upon as favorably as click-wrap agreements by the courts, are they?
I mean, it's true. It is not a click wrap. I think that the courts have recognized that click wrap provides the clearest form of notice. But I think importantly, Your Honor, courts long before click wraps were so common recognized that other forms of interfaces also gave rise to enforceable contracts. And that's what Meyer was about. The interface that's at issue for her case in 2016 is very, very similar to the interface that the Second Circuit found appropriate in Meyer. And of course, this court just recently in Brooks said that the Second Circuit's reasoning is an accurate description of New York law.
Should there have been a warning that that by accepting this revised arbitration provision, that it could affect any pending litigation?
Well, so Your Honor, I mean, just to be clear, in 2016 there was no pending claim. That was before her accident. So not. I think that the easiest way to resolve this case is to say that the 2016 interface gave rise to an enforceable click-wrap agreement, and then we wouldn't never ever get to any issues of retroactivity or anything.
I'm sure you would like us to think that, but let's assume we're not going to think
Sure. So I think if we come to the 2021 interface, the click-wrap interface, the very same one that was at issue in Brooks, I think the straightforward answer to Your Honor's question is no. There's no legal obligation on Uber to identify precisely which terms are important. But what Uber does say, and what I think is key, is in 2021 in the click-wrap interface, Uber said, we encourage you to read the terms in full. And then when you click on the hyperlink and you read the terms, it says, take the time to carefully carefully read these terms and understand the consequences of this decision because it's important. And then I think the key provision that is in the record at page 118 is where the terms and conditions explain that the plaintiff is agreeing to arbitration of any dispute that she may have with Uber, quote, whether that dispute, claim, or controversy accrued or occurred before or
Can you
after
dispute
the
the
date.
fact, counsel, that the arbitration provision from January 25th, 2021 was put together by an attorney at Uber?
So, Your Honor, I think I want to be very, very clear about this because I think it's very important. The retroactivity provision that my friend objects to was added to Uber's terms and conditions in 2016. You can see that in the record at page 251. So 4 years before this accident occurred, Uber amended this terms and conditions. Now, I don't know exactly who was involved in that. It wouldn't surprise me, of course, if legal counsel was involved.
It would surprise me if it wasn't legal counsel.
But Your Honor, I think there is never in the history of Rule 4.2 that we have been able to find been a case where in-house counsel was advising a client and it said about the standard terms and conditions that it was going to offer to all of its customers. And that legal advice was held to create a professional responsibility violation. I think it would be stunning to the in-house counsels in this jurisdiction to learn that when they give advice about standard terms and conditions, not focused on a particular lawsuit or a particular plaintiff, but just what contract terms should we make available to everybody, that can create a professional responsibility violation. That's a very serious charge for the in-house attorneys at Uber and all other companies that take their obligations seriously.
Of course, it's reasonably foreseeable that the email would go to individuals who had a pending lawsuit.
But the nature of the no contact rule, Your Honor, is that it requires contact. It requires a communication between an attorney and a represented party about that communication. There's at least 2 or 3 elements of that can't be established. There was no communication in this case between any Uber attorney and Ms. Wu. Fails right there. Second, there was no communication about the subject of Ms. Wu's case. When Uber's attorneys were communicating with them about these standard terms and conditions, that was 4 years before Ms. Wu's accident. I just want to say one word, if I might, about the Nicosia point. I think that, too, is also very, very simple. And if the court has any questions about retroactivity, if you find that issue difficult and you don't want to get into what to do with a pending lawsuit, the easiest way to resolve the case is to just say that Ms. Wu and her counsel knew at the time of the demand for arbitration that her use of these services was conditioned on her acceptance of the whole terms of the contract, including the arbitration provision. And with that actual knowledge, she took 19 more Uber rides. That, under Register.com and Nicosia, clearly gives rise to an enforceable contract.
Thank you.
Thank you.
Thank you, Your Honors, and by necessity, I'll be both quick and brief. First, it's interesting to me that we're talking about the 2016 terms because this court just found in Gem v. Castro that the 2016 terms were inadequate and didn't give appropriate notice. Courts around the country, including in Sarchi, in Cowders, in Ramos, in Brooklyn, all of them have found the 2016 terms of use weren't properly presented to users. And so when Uber was sending out their new terms recently, it's because they knew that those terms had been found unenforceable across the country. Second, as to Nicosia, that's a non-precedential opinion. What Uber is saying is that they could tell Emily Wu, you can only accept these terms by clicking a button. Then they could change it to by taking a ride, not tell her, and then turn around in a court when they find their position problematic to defend and say you accepted it by accident. The whole premise of their argument is that you can accept an arbitration clause by accident, which is contrary to the fundamentals of any contract law. And then finally, they say, and I want to close on professional responsibility, that it would be stunning for in-house counsel to know that they could be held to professional ethical principles for sending lots of emails to all their users. If anything, that makes it even more important to apply those ethical principles. You know, it's said in a lot of the cases that the law of contract doesn't cease to apply on the internet, but neither does the law of professional responsibility. 50 years ago, if a lawyer was going to avoid the no contact rule, if they were going to breach it, they would pick up a phone or they would show up at someone's door, they would make direct contact. Technology makes it possible to breach the no contact rule on a mass scale, to affect not just one case, but many. That's what Uber's lawyers did here. They knew by sending this email, they would be trying to sweep in numerous cases involving represented parties. And then here we are in this court with Uber trying to enforce it against Emily Wu, when they know that if they walked into a preliminary conference in the Bronx in this case and said, hey, would you like to go to arbitration with no parameters, no high-low, and give up the jury you've already demanded, the answer would have been a resounding no. The court should not enforce or countenance what Uber did here. Thank you.
Thank you. Thank you both. SKW Hillside versus Rabizadeh.
If it pleases the court, Greg Zucker on behalf of Holmes & Moore LLC and Albert Rabizadeh. Thank you for oral argument. We appreciate it. This case comes down to a simple issue, real property law 25410. It says 3 times the words entitled to. In the caption, it says mortgagee entitled to appointment of a receiver. It says that if the borrower and the lender agree in the underlying mortgage that in the event there's a foreclosure, the lender shall be entitled to a receiver, then the statutory presumption exists. That's not the case here. The mortgages, all 4 mortgages say something very different. They say the lender, on the event of a default, they may apply, they may request. We've all dealt with the situation in the context of a non-disclosure or a confidentiality agreement where parties negotiate the remedy, whether a person is entitled to a TRO and preliminary injunction or whether they could apply for it. Here, the language says apply. There's no doubt counsel's going to get up and say the language is substantially similar. It is not. Again, the statute says 3 times entitled to. The language in this mortgage says they may apply. The language is to protect the borrower, not the lender. It's supposed to give certainty to the borrower as to what their rights and ramifications are. They knew what the statute said. They drafted the document. If they wanted to deal with it, they could have put it in the loan document, but they did not. The case law supports us. We cite numerous cases for that proposition. The 31 East 28th Street case is exactly on point. It says may apply, does not result in a statutory presumption. The Wells Fargo case goes even further. It says that even if a statutory presumption applies, under those circumstances, as a court of equity, you still have to delve into the facts to see if a receiver is warranted. This court held the same thing in a case called ADHY. It's directly on point. It's important that the statutory presumption doesn't apply because they did not move under CPLR 6401A at the lower court. They did not show that there was going to be a loss or material damage to this property, nor could they. Because my client owns the Avon property. There's a McDonald's there. There's one tenant. That one tenant pays $45,000 per month every single month. The mortgage here was $17,900, and they directly removed the money from my client's account. There was never any danger. There's no violations. There's no insurance issues. The McDonald's tenant takes care of everything. Plus, as it relates to my client and the Avon property, the mortgage was $3.6 million at the time of the alleged default, and the value of the property was $11 million. In their own record, in 740 of the record, they said that 6401A does not apply. They acknowledge that it doesn't apply. Even if the statutory presumption existed under the real property law, the receiver should have still been denied. Why is that? Look at the facts here. There was never a default. There's the Bleecker Street property and the Avon Street property. We agreed that in the event that the Bleecker Street property was renovated and constructed, then what would occur is the cross-collateralization would go away. That was a fundamental deal. That's why my client wrote in August of 2017 and said, take away the cross-collateralization.
That never materialized, right, counsel?
Say?
That never materialized, did it?
The cross-collateralization? We believe it did. We believe that it's governed by these emails that exist and the internal records that we've seen from Bank United. We wrote, please remove the cross-collateralization. Judge, they didn't say no. They said the opposite. They said, I will start the process. When we followed up again, they said, we apologize. It'll be documented shortly. And it's the type of case where it's the proof in the pudding, because what happens is, in May 10th, 2021, the Bleecker Street mortgage matures. But yet 8 days later, even though there's this alleged cross default, they extend my loan for 5 years? That doesn't make any sense. Every case they cite supports what I'm saying. Even the Ridgewood case, that was the one that went the opposite way, that said the may apply was tantamount to entitled to. But even there in Ridgewood, that judge goes through the analysis that you're supposed to. They look at the property on Walton Avenue in the Bronx and they say, look, it was once 97% occupant and it was renovated. But now look at it. There's mold and there's plumbing problems and there's 238 violations. A receiver's warranted here. Even the C-sale case they cite, which is the other case, it says actually at 28D of their mortgage in the docket that in the event that there is a default, in that circumstance, the lender is entitled to the appointment of receiver. What they cite supports us. They cite to 10A of the mortgage, but 28D actually has the magic language. And in the C-sale case, just like in the Ridgewood case, there were conditions that warranted the circumstance of a receiver. There was liens, there were violations, there was no insurance, there's real estate taxes. This is not the case where there's a receiver. It's a performing loan, and you have a situation where you have a special purpose entity that was created right before the foreclosure, and the reason why they're seeking a receiver is to assert leverage of us. There's no danger.
May it please the court, my name is Robert Tills of Mard, Hock, and Hamroff, and I'm here for SKW Hillside Bleecker Lender, LLC. I think that the appellant's argument here really misses the point. And to explain that, I need to take a minute to walk through Real Property Law Section 25410 and what it does and what it's intended to do. The precatory language says, in mortgages of real property, the following or similar clauses or covenants must be construed as follows. It's clear by its own language that you don't need to follow the exact language, it just has to be similar. And then the substantive section, subsection 10, that deals with the appointment of receiver has two clauses. The first clause says, a covenant that the holder of this mortgage in any action to foreclose, it shall be entitled to the appointment of a receiver, a covenant that the holder of this mortgage in any action to foreclose shall be entitled to the appointment of a receiver must be construed as meaning, and then it goes into the second part, clause B, the mortgagee, his heirs, successors, or assigns in any action to foreclose the mortgage shall be entitled without notice and without regard to the adequacy of any security for the debt to the appointment of a receiver of the rents and profits of the premises covered by the mortgage. And then there's some additional language. So what this does, the legislature actually gave mortgagees a shorthand way to write an even longer receiver clause that contains the language that they need not address the adequacy of the security. So now let's look at the actual section of the mortgage and see how it ties in with that. So section 2.2A8 of each of the mortgages starts out with the first clause that's similar to what I called the clause A in the real property law. It says, upon the occurrence of any event of a default, the mortgagee may, in addition to any rights or remedies available to it hereunder or at law, take such action as it deems advisable to protect and enforce its rights against the mortgagor and in and to the mortgage property, including the following actions. So it's clear that this is a grant of rights to the mortgagee. And then the subsection 8 of that, which equates to the second clause in Real Property Law 25410, says that they have the right to apply for the appointment of a custodian, trustee, receiver, liquidator, or conservator of the mortgage property without notice and without regard for the adequacy of the security for the debt and without regard for the solvency of the mortgagor or of any person, party, or any entity liable for the payment of the debt. So what they do here is, whereas the real property law says, if you write something similar to A, then you get B, they expressly state the B part in the mortgage. This is an absolute agreement by the mortgagor that should there be an application for a receiver, it shall be without regard to the solvency of the mortgagor or of the regard for the adequacy of the security for the debt. And that's exactly what Article 64 of the CPLR is all about. Article 64 of the CPLR that the appellants want to rely upon is there to protect a party with an interest in property if there's going to be a diminution of the adequacy of the security. And the appellants acknowledge that.
Thank you.
On page,
Sounded like you got to a point.
thank you, I'm done, or thank you, I can,
Well, it sounds like you ended. They acknowledge that.
well, they acknowledge that in their brief that that's what Article 64 is about. And here, they've absolutely waived it. And there are a couple other points I wanted to make, but I know that the light's on and it's been a long day, so if you'd
I
prefer.
gave you
I
every
end here.
minute you asked for. Thank you.
Thank you, Your Honor.
This court in ADHY said this, that even where there's the statutory presumption, as a court of equity, you still look at the underlying facts and circumstances. There, in that case, 19 out of the 20 apartments were rented. There was no problem with respect to the property, and this court held that it was appropriate to deny the request for a receiver. Counsel cited to the statute 25410. This is not similar. There's a big difference between saying I am entitled to something or I may seek to apply. I may make an application. It's of no moment as to whether it's on notice or not. Rip Apple 1325.1 says that when you are seeking an appointment of receiver, you don't have to do it by notice of motion, which just means it's an order to show cause. They drafted this language. They could have said, at their option, they're entitled to a receiver. They did not write that. Thank you, judges.
Thank you both.
So when you go last, you got to stand.
We'll be working together, I guess.